In view of the aforesaid facts and circumstances, we are of the opinion that the impugned order dated so-and-so passed by so-and-so does not call for any interference. Reputation is dismissed.
The concept other side, I want item number 41. I prefer response first.
Yes, what do you want?
After vacation immediate.
On a request made by Sri S. Islam Learned Council for the petitioner, matter is adjourned to be listed after the autumn vacation. Sri N. Goswami, Learned State Council, and Sri A.I. Ali, Learned Standing Council, ECI, are present. Yes.
The motion matters may be listed, my lord.
When?
On 19, my lord.
So day after tomorrow.
Yes, ma'am.
May I please, your lordship? I beg to mention for listing one repetition for Monday, lordship.
For
Admission column,
matter of which year?
2025, lordship.
What is the urgency?
Lordship, petitioner challenged the order passed in Lok Adalat, lordship. Alleged that
What is the urgency that it has to be listed by out of turn?
this matter was last listed.
Sorry. Only urgent matters.
May I please, your lordship, with the consent from the other side, I beg to mention item number 22.
22.
22.
22.
Lordship, it may be taken after puja vacation.
Yes, on a request made on behalf of the respondent, matter is adjourned to be listed after the puja vacation, after the autumn vacation. Yes.
Much obliged.
May it please your lordship. Lordship, with the consent of the other side, I beg to mention item number 35, lordship.
35.
35, lordship.
Yes.
Will be taken after puja vacation, lordship.
35 was the which year? Which year?
18, lordship.
18 matter. So sorry.
There is
No,
perhaps matters become infructuous,
So
lordship.
they will declare to be infructuous. We are not going to adjourn a matter of 18 till the vacation. Let the matter reach. Yes.
May it please, my lord. My lord, with respect to item number 4 and 5 of the daily list, my
Yes.
lord. May I pray for listing this matter on the next Monday, my lord, as our instructions are awaited, my lord.
Yes, I informed the other side. Yes. On a request made on behalf of the Finance and Taxation Department, matter is adjourned till Monday date to enable seeking of instructions. Separate orders in 4 and 5, Monday. Yes.
Much
I'll
obliged.
bless, my lord.
May lordship bring for listing to matter for motion lordship.
When? Monday?
Of lordship.
May I please, your lordship, I beg to make a mention for item number 36 of the daily list.
Yes.
Lordship, in this matter, pleadings are completed, your lordship. Rule may be issued and the matter may be fixed for hearing after the vacation, your lordship.
Item number?
36.
To issue rule, you have to see the file. We cannot issue rule at the motion stage, at the mention stage. Don't make a prayer like this, issue rule. What is the issuance of rule? Do you know? What is meant by issuance of rule? Is it a matter of routine? In the mention, you say issue rule.
Lordship, pleading
What
was
is-
completed.
So pleadings are complete, so what is issuance of rule?
I apologize, your lordship, in that case.
You should know. Why aren't you required to know what is the rule, what is the notice? What is rule nisi? Should know. Rule is an admission. We don't admit on a motion mention stage. We admit we have to see the file. Okay? Let the matter reach. Yes.
May I please, your lordship? Lordship, I beg to mention two repetition for listing for motion, lordship.
When?
Friday.
Urgent matters.
Yes, eviction matters. Eviction.
Eviction, okay.
May it please your lordship. Lordship, item number 32, it was fixed as a motion item, lordship, today, but wrongly it has been come in admission column. May I
What will
please
happen?
that matter may be
We'll
taken as
take it
a
as motion, doesn't matter.
last motion item, my lord.
The other side is required to be there.
Well informed, lord.
Yes, if they are there, we'll take it up.
Much obliged.
32 motion bole.
Mayor, please, your lordship.
Yes,
I beg to mention item number 19.
19.
Yes. The petitioner wishes to withdraw the petition.
What is your name?
A. Burman.
Your A. Burman, Sri A. Burman, learned counsel for the petitioner, has submitted that there are instructions from the client not to press this writ petition,
Lordship,
Sir.
liberty to refile.
press this writ petition. Full stop. However, he has prayed for a liberty to file afresh para. Also heard Sri N. Goswami, Learned State Council, Ms. G. Hagarika, Learned Standing Council Revenue. CGC, any CGC in the court? Yes. UK Goswami, CGC, and APDCL. Any APDCL council in the court? KP Pathak, Learned Standing Council, APDCL para. Writ petition is accordingly dismissed on withdrawal with liberty as prayed for.
Yes.
Yes,
May I please, Lordship?
yes.
Lordship, I'd like to mention the writ petition, Lordship. Lordship, the matter relates to land sale transfer and the petitioner has been suffering from, acute financial constraint, Lordship. It has been more than 6 months, Lordship.
So what do you want?
Lordship, may it be listed on any day late next week, Lordship.
Not a matter for out of turn listing, sorry. Yes. Okay.
Right, Lordship.
May I please, Lordship?
Yes, Mr.
My lord, the order passed by this noble court, Lordship will find at page 18. And my lord, authority part at page 37, last para, my lord. Page 37, my lord, last paragraph, my lord.
Page
Page 37.
37.
37, last para, my lord. In view of the aforesaid submission made by the learned counsel for the petitioner, this court is of the considered view that the instant case may be disposed of in the interest of justice within the direction to the respondent authorities to dispose of the representation of the petitioner dated so and so in accordance with the law within a period of 2 months from the date of receipt of the certified copy of this order. That was the direction.
Yes,
And it was communicated to the respondent authorities, Lordship will find at page 38.
who were supposed to consider and dispose of your representation?
Particularly DC, Deputy Commissioner, District Commissioner. Now, last occasion, this honorable court was pleased to direct us whether the Deputy Commissioner is the competent authority in view of the scheme, PMGY. Now, we have filed additional affidavit, Lordship will find at page 53.
53.
53.
Yes,
There is a district collector is the nodal officer.
yes,
Page 53, Lordship will find.
yes.
In Sijon Circle, Assam, for Pradhan Mantri Awas Yojana, Gramin, PMAY-G, the district collector DC serves as the nodal officer overseeing the scheme's implementation, ensuring the beneficiary selection based on the so and so.
So who are the respondents here?
Now here, district commissioner is the one of the respondent here.
Where is your representation to the district commissioner?
Page 38.
Where is the receipt?
Yes, it has been through Gmail.
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 But will issue notice at this stage to
Madam.
respond number 1?
My lord.
Heard 3 M.U. Mandal, learned counsel for the petitioners who by means of this petition has alleged willful and deliberate disobedience of the order dated 22/10/2024 passed in WPC 1690 of 2023. Full stop. The learned council has submitted that it is the district commissioner who is in charge of the scheme. Full stop. Para. Issue notice, which is restricted at this stage to the respondent number 1 only. Para. That steps be taken by registered post with AD steps within 2 days.
Right. Developers.
Oh, I would like him. The Learned Council has also drawn the attention of this court to the representation submitted for compliance with the order. Officer, this will notice.
Yeah, please. Your Lord. Yes, order this is page 56, my lord. Relevant portion is page 62, my lord.
62.
62 relevant portion, my lord. In view of the aforesaid statement, this court is of the view that there is no requirement to continue this with these repetitions, and IAS accordingly the same are disposed of by directing the private respondent to serve the copies of the applications for demarcation on or before the date fixed. It is also provided that the circle officer who would undertake the demarcation would give a due opportunity to all the stakeholders, including the writ petitioners, before passing any final order. Let the date for appearance of the parties before the circle officer be fixed on 27/8/2025. Whereafter the circle officer shall conduct the proceeding in accordance with law. My lord. He appeared before the circle officer and filed a representation, my lord, and communicate the order of this honorable court, my lord, but private respondent did not appear, my lord. He demarcation application also not supplied, my lord.
Who was the Learned Counsel for the private respondent in that case? Somebody had appeared.
Earlier appeared, my lord.
So what order was passed on 27/8/2025?
No order was passed, my lord. We
What?
appeared, private respondent did not appear.
No, no.
Also-
Where is your statement?
Statement is, my lord, in paragraph 11 and 12.
11 and 12.
Yes, my lord. 11 and 12.
How have you verified the averments of paragraph 11?
Worship, he wished to acknowledge the same, my lord. If my lord.
How have you verified?
Worship,
Paragraph 11 averments have been verified. How have you verified in the affidavit? Paragraph 11 says that on such and such that you had appeared, given copies,
Yes.
no acknowledgement given. Verification is as per what?
Yes, my lord. That,
How have you verified?
next, my lord, paragraph 12 may be seen, my lord.
We are asking you, how have you verified paragraph 11 in the affidavit? Where is your affidavit? Come to the affidavit portion.
Yes, my lord.
How have you verified? Matters of what? Records. You were there, no acknowledgement given. These are matters of records. This is not how you verify. Contempt has got entails penal consequences. You cannot proceed like this. And affidavit, don't take affidavit so lightly. Mr. Counsel, we don't have anything else. It's only the affidavit we are dependent upon, which verifies the pleadings. You don't reduce evidence. Do not present petitions like this. Heard Sri H.A. Laskar, learned counsel for the petitioner, who by means of this petition has alleged willful and deliberate disobedience of the order dated 14/8/2025 passed in WPC 4554 of 2025. Full stop. It is submitted that on the date fixed by this court by the aforesaid order, comma, the petitioners had appeared before the respondent number one, who had in spite of which no action was taken for demarcation, full stop. He has also alleged that the respondent number two did not even appear before the respondent number one on the date fixed, that is i.e. 27/8/2025. That notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respondents by registered post. Any steps will include this.
Most of it.
Settled? You said? Oh, what of this, what is it? Oh, maybe, this is yes. I have the instruction lot, so they have submitted it on 2/9. My lord, might have been, my lord, I have no information. Anyway, my lord, your losses may.
We'll record this.
Yes,
and
your
then
lord.
we'll close this.
Your lordship.
Heard Sri G.N. Sahar, a learned senior counsel, assisted by Madam
K. Sharma.
K. Sharma for the petitioner. Also heard
And
Sri
Goswami.
N. Goswami,
For
learned
20.
state counsel. And you are also there, Madam, as well as Ms. G. Hazarika, learned standing counsel, Revenue Department, Para. The grievance of the
Well, the action was there by the additional district judge, my lord.
the grievance of the petitioner is with regard to the inaction of the respondent authorities to comply with an order dated 13/11/2024 passed by the learned additional district judge, Jorhat, in a proceeding under section 64 of the Right to Fair Compensation and Censure Act 2013. Full stop. By the said order, the respondent number two, the said order, by the said order, a direction was given to the respondent number two to make a reference in terms of the said act, full stop. The grievance of the petitioner is that the said order was not complied with in spite of the clear direction, full stop. When this matter had come up for consideration on the previous dates, namely 28/2025 and 27/8/2025, the learned state council was given, was directed to obtain instructions with regard to the follow-up action, full stop. Sri Goswami, the learned state council, has submitted that on
2/9, yes, lordship.
2/9/2025, the reference under section 64 of the act has indeed been made, correct?
Reference taken, yes, lordship.
Full stop. Okay, it is a form of a what? Letter or what?
Letter, lordship.
Please give up.
I'll give, lordship. Along with documents, madam. Yes.
Along with the documents to the competent authority. Sri Goswami has also placed before this court copy of the communication dated
Lordship. 2/9,
2/9 itself,
lordship.
2/9/2025. The learned senior counsel for the petitioner has submitted that though he does not have clear instructions on this issue, comma, he has fairly submitted that in view of the aforesaid instructions, comma, the writ petition, there may not be any further grievance
Well-
to be espoused, where in view of the above situation, comma, this court is of the opinion that there is no requirement to continue with this writ petition any further, and accordingly, the same is closed. The written instructions
Okay, I'll
dated
give
so and so is made part of the records.
Okay.
29, huh?
May I please, your lordship? This is regarding compensation, lordship, payment of compensation for acquisition of land of the father of the petitioner, lordship, who expired before, before issuing the notice, an acquisition for acquisition, lordship, hearing notice, the father was expired, lordship. So it was not known to the petitioner, and she has other three sisters also. In 2017, lordship, the petitioner came to know, and she approached the authorities, lordship, for only compensation of the land which was, and in the meantime she inquired, lordship, her father's name has been deleted, and the name of the respondent number 5 has been incorporated in Jamabandi, lordship. Only prayer to pay our, since we are
See,
living.
madam, you are 55 years of age.
Yes, sir.
Father died in 2008,
8, lordship.
and you are coming to the court in 2025.
Yes, lordship.
It is not a
Because-
case that you are a minor at that time, you are not aware.
No, I was a lordship. Actually, that was not known to us, lordship. And
Can you
the
come to
delay-
this court to make a recovery kind of a suit? It's a recovery suit.
Lordship,
In the guise of a recovery suit, you are filing a writ petition.
no, lordship. Since we discovered the notice, we approached. I discovered the notice. We approached the authorities. They didn't take any action, lordship.
When did you discover the notice?
Lordship, in para number 2017, lordship.
What did you do from 17?
Page number 8, page number 8, lordship.
8.
Sir, help me.
Para 5, lordship.
Para 5, yes. Since your knowledge, where is the knowledge?
On lordship, July 2017, para 4, page 7, I have also stated that, lordship.
Suddenly discovered. From,
Lordship, I'm married daughter, lordship.
how did you suddenly discover in July 17?
Maybe in my father's house, lordship.
And some 17, what did you do?
I filed an representation, lordship.
Thereafter, you waited till 2025.
No, they did not do anything, lordship.
So you waited, you wait for another 10 years, you come in 2035. What is your explanation, even from 17?
Lordship, for this condonation of delay, lordship, the Honorable Supreme Court also said the humanitarian ground may be.
What humanitarian ground?
Delay is there, lordship. It is admitted.
It's not delay, it's laches on your part. You are not diligent. It's a court of equity. We do not entertain persons who comes to this court without any diligence.
Lordship, may kindly see. Order of Honorable Supreme Court.
First, you make up a story that in 2018,
Lordship.
you suddenly came to know. You are not a
Seven-
child. You are a 55-year-old mature woman.
Now I'm 55 years old.
Even that time, 2008, how old was you?
16 years back, yes.
You were not a child.
Yes, lordship. At least, lordship, compensation is cannot be denied, lordship. We are the legal heirs, lordship. That's why.
Cannot be, your entitlement in law has to be balanced with your
Lordship.
approach. If you sleep over your rights,
Lordship, I have to judge.
and why is the limitation act there? Remove the
No.
limitation act,
No, lordship, I
not
have
required.
to judgment of Honorable Supreme Court, lordship,
Yes.
saying that lordship.
What does it say?
Lordship, may I read, lordship?
Petition.
2014-14 SCC, 127. Para 15, equities can be balanced by denying the appellant's interest for the period, Lordship. The substantive right of the appellant should not be allowed to be defeated on technical grounds by taking hyper-technical ground of self-imposed limitations, Lordship. And the principle regarding condonation of delay, particularly in the case of land acquisition matters, Lordship. It have been enunciated in a judgment that is quoted, Lordship. The legislator has conferred the power to condone the delay by enacting Section 5 of the Limitation Act. Lordship, may kindly peruse.
You
judgment.
are applying section 5 in a writ proceedings.
No, Lordship,
We are in a writ proceedings, madam.
yes, Lordship.
Please confine your argument to a writ proceeding.
Yes, that is
We
there,
don't
Lordship.
apply an act. Spirit may be applicable. We condone delay in a matter where there is a necessity. How do you explain?
I have explained in paras, Lordship.
Oh, that
Why-
representation is not an explanation. Where are the acknowledgement of the representation? That they have taken some,
In 2017, I forgot, but recently they denied to acknowledge.
no, the 17, where after the 2017, you had said you had represented.
21, he has filed the representative 21 lots.
No, 17 I have filed. and
17, where is the acknowledgement?
Acknowledgement is not there.
Then-
In that case, Lordship may provide me few days time. I will submit, I will produce some other judgments. I mean, Lordship, regarding the.
Judgments
till-
are not going to help you. You have to make out facts for interference.
Few days time may be given to us, Lordship. We will submit some
Or
judgments.
Ms. S. Kanungo, learned counsel for the petitioner, who by means of this petition is paying for a direction for payment of compensation for land acquired, full stop. It however transpires that the land was in the name of the father of the petitioner, who had passed away in the year 2008. Full stop. The first representation which the petitioner has claimed to have made for compensation is also of the year 2017. Full stop. The petition on a perusal of the averments column, the explanations, there are no acceptable explanation for the inordinate delay. Full stop. At this stage, the learned counsel prays for some time to obtain instructions.
No.
List on when is the next?
After puja, Lordship, vacation, reopening.
After puja also bench 5 will be this court.
Doesn't matter, Lordship. Okay, next Wednesday, Lordship.
Now if you wish, after the,
No.
take a chance. You should not be deprived of a chance.
No, Lordship.
Okay, the list, after the list on 15th of October.
Lordship, deeply obliged.
May please, your lordship.
Yes,
My lord, here, my lord, the petitioners are all patta holders.
Hmm.
Their grievance is that their land earlier was occupied by the PWD. No compensation, no procedure was followed. Again, my lord, in 2000, since 2024, my lordship will kindly have a look at page 48. They had again started to occupy our land by for the scheme of Assam Mela to improve for improvement and upgradation of Kokrajhar to Rupsi Airport
Hmm.
phase 1
Hmm.
package. So we have grievance against this process. They have in meantime surveyed and they have started to work, but we have made some representation in the meantime. Also served legal notice. They are starting the process again without following due procedure, my lord.
why, what due process?
My lord, they are to acquire the land in the under Land Acquisition Act.
Not
or
done.
That those things
Yes,
are not
Mr.
done.
Bukhari.
Spot is
Huh?
instruction for instruction.
You cannot take their land without an acquisition
Right.
proceeding.
Well,
They will be entitled to a fair compensation.
My lord.
But what is the status now, Mr. Sigdar?
My lord, we have made some representation. After representation, we have not noticed now their work is not noticed now. That is that we have reported. After the representation, they have stopped the work, but they have started in the meantime.
Part 3A.R. Sigdar, Learned Counsel for the petitioners. The primary grievance of the petitioners is forceful acquisition of their patta lands without following the due process of law. Full stop. Let notice be issued, returnable on 13th of October 2025. PWD, Madam H. Borwa, for PNAC. PNAC 1, PWD 1, 2, finance also. Okay, PNAC, PWD and finance, 1, 2, and 3. Revenue Department, revenue. Oh, this is, I think, you will take, I think.
Revenue, my lord.
Yes, revenue for BTC.
4, 5, 6, 7.
4,
Eight.
5, 6, RK Mushahari, 4, 4,
4,
5,
5, 6, 7, 8.
7, and 8. Standing council BTC. Okay, extra copies. Yes.
Deep level.
Serve extra copies.
File.
Within 2 days, standard is only. Yes, Dr. Sarab, what is this?
A notice under section 158A was issued to me, Miller.
Yes,
And you will also find the notice, wherein no details were given, Miller.
additional affidavit file.
My lord, file. You also may see, Miller, at page 150
Of the additional affidavit,
of the petition, Miller.
page
150,
150.
my lord. Nothing, no details were given. Simply it was said that this is the amount, etc. I submitted the reply at page 152 to provide me the informations that for which are the amount, and we have specifically stated, my lord,
Yes,
that no amount was issued by us. Thereafter, my lord, a so-called notice was issued to me, which you'll also find at page, my lord, 166.
yes,
Page 166. This was also a notice, and also may see page 167. A chart was given of the
Yes.
tax deducted source. And again, my lord, at page 178, the same was repeated. Now I submitted reply saying that the income tax, income from interest, etc., in respect of which the TDS has been shown, is already reflected in the return, and that is shown here. Lordship may see the return. The amount was shown at page, page 56.
yes.
You also find the column 5. 4, my lord.
You said that the TDS have already been reflected in your
See,
return.
income was also reflected, interest income was also reflected. But in spite of, my lord, the same, the 148 notice was issued. Again, repeating the same grounds, again on the same amount, and without giving any, my lord, particulars for the amount received. I gave an affidavit also that during the years, no amount was received by us, which you'll also find at page 240 and 215. 215, my lord. 215, 16, my lord, that no amount whatsoever was received, no information, whatever is there, my lord, and we have been asked that you explain, my lord, wherefrom we will explain, my lord. And similar situation, my lord, recently I came across a judgment that when the informations are not furnished and the notice are issued, then the 148A notice order was passed, my lord. Para 8, you'll also see. Lord, if I'm not given the information that which amount you are asking for and where from it is coming, and I'm asked to, explain where from the amount is coming. Whereas I have specifically stated, that no amount was received by us.
Yes,
And 148 notice, the purpose of 148A is frustrated because it says, to show cause and thereafter reply submitted and thereafter orders to be passed. Now here, the same thing has been repeated again in 148A notice, 148 notice.
yes, Mr. Chetty.
Lordship, it is only a notice, my lord, prior to issuance of notice under section 148, my lord. It is in fact a pre-notice, my lord. And my lord, the order was passed, my lord. Your lordship will find that page 200, that is in the additional affidavit.
Yes,
File.
yes.
Lord, relevant portion at page 212, lordship. Everything was discussed, lord. Page 212. From the above, it can be seen that the assessee has stated in the information is incorrect and has only submitted an affidavit in this regard. Also, the assessee has only stated the details and had not furnished any corresponding evidences for the nature and of the transactions. From the record, it is seen that the information which was shared as per the RMS cycle was party of an STR shared in the investigation officer which was investigated upon and the trail was established. Further, the assessee is one of the beneficiary of routine of funds and non-existent entities. So, lordship, the information was examined, my lord. It is in the portal of the, my lord, the CBDT, lordship. And detailed start was already given, my lord. And it was categorically stated, my lord, that these entries were, my lord, not reflected in
But
the...
what about the mandate of law that you are required to give the information if you issue a notice under 148A? That is one of the interpretation by division bench of another high court,
Lordship,
but nonetheless,
Lordship,
we'll
that is...
examine.
Otherwise, when somebody says that 10 crores rupees you have received. Now, if no information is received, how I give reply that 10 crores, where from it is coming? They say that in our system it is there. Where from the system is there, where from the amount is coming? How I give reply?
Have you disclosed your accounts? Obviously, you have disclosed your accounts.
We have given all the accounts.
And you have denied of receiving
Yes,
this.
yes.
Okay, you should not.
Lordship.
You have to file your affidavit. Let
Lord.
us know what is your stand. Okay.
Lordship.
Third, Dr. A. Saraf, Learned Counsel, as assisted by Sri B. Sharma for the petitioner. Para. The present challenge is with regard to a notice dated 26/6/2025 issued under section 148 of the Income Tax Act 1961, whereby the petitioner, which is a private limited company, has been informed that the department has received information that income chargeable to tax has escaped assessment within the meaning of section 147 of the Act. Full stop. Accordingly, it was concluded the same to be a fit case for issuance of notice under section 148. So, para, it is the categorical case of the petitioner that no such income was received, and in this regard, the petitioner has also filed an additional affidavit pursuant to the earlier order of this court on 5/9/2025. Para. So as Chetia, Learned Standing Counsel, Income Tax Department has, on the other hand, submitted that there are clear materials based upon which such an action has been proposed. Full stop. Para. Let notice be issued. Returnable on, will give a date. Returnable on 22nd of October. Or returnable on 17th of October, 2025. 3. Chetia, the Learned Standing Counsel accepts notice. Oh no, you never in the Finance Department. Anybody? CGC?
Well, we'll send the copy on the.
He's there. Sri UK Goswami, Learned CGC. For 1. And rest, I think, Mr. Chetty.
Yes, Lordship. 2, 3 and 4.
For 2, 3 and 4, extra copies be served upon the learned counsel for the respondents by tomorrow. What is the stage now?
Well, the notice is issued, no action has been taken as yet. So my prayer in this case is again, that since 148 notice has been issued, no information is there. And nothing is there. At least for the time being, my lord, the further proceeding may be stayed, otherwise, my lord, we will be harassed. When information is not there.
No, but proceeding, can we say a proceeding?
Lordship,
My lord, in all
You don't
cases-
take any final decision?
Lordship, in other case, Lordship filed by the same SSC for different assessment here. Lordship has permitted to proceed, my lord.
Yes.
My lord, in this case, my lord, in the earlier case, just my lord, subject to your lord.
Yes, yes.
My lord, in this case, since the information, nothing has been given, how they can proceed for the assessment or under proceedings? My lord, otherwise, my lord, how I am repeatedly saying that information is not there.
He dare not take any coercive action against you. You will not stay the proceeding, will not have a blanket stay.
Lord.
You don't take any coercive action.
And no final order should be passed.
No, yes. So Dr. Saraf, the Learned Senior Counsel prays for an interim order, which however is strenuously opposed by Sri Chetia. Para, considering the facts and circumstances, comma, while this court is of the opinion that no blanket interim order is required to be passed, comma, it is provided that while the proceedings may go on, comma, no final orders may be passed without taking the leave of this court. So it is further provided that no coercive action be taken against the petitioner.
I am obliged, my lord.
Obliged.
May I please, your lordship?
Yes.
The petitioner is a reporter of weekly Bengali newspaper of Ronobhumi, circulating in Bharat. And being a reporter, he had submitted an application under section 75 and section 6 of the Bharatiya Saksha Adhiniyam for furnishing certified copy before the response number 3 and 4. But the response number 3 and 4, I have annexed as annexer 3, page 14 and 15. Forwarded the letter to the all circle supervisor and the sector supervisor for providing the documents.
You had applied for the documents under what provision?
Section 76 of the Evidence Act.
You applied.
Sorry, Bharatiya Saksha Adhiniyam.
Let us see. Then how do you come to a read code? What is the provision? Provision section open from this.
Section 75, my lord. Page number 61.
Just a minute, please. You asked for certified copies.
Yes.
Thereafter?
But till date they have not furnished the certified copy. And the child development project officer forwarded it to the all sector supervisor, page number 15 in my petition. And within 7 days, they have in that letter to provide the certified copy within the 7 days, but till date they did not provide the certified copy. Therefore, I have approached before this honorable court to fix a date by framing a time limit, and a direction may be given to the
You have a right to inspect such document.
Yes, my lord. It is a
Why?
public document because
No.
Section
Which-
74 provides public or private documents. I
Yes.
have one citations also, my lord.
Yes. Yes.
Section 74 in para 4, my lord.
Yes.
Section 76 of the Evidence Act enjoys early, now it was, it is section 75 of the Bharatiya Saksha Adhiniyam. Section 76 of the Evidence Act enjoins a duty on every public officer having the custody of a public documents to furnish a certified copy of the same to any person who has a right to inspect the said documents. It also provides the method and manner of preparing certified copies.
Now, how are you connected to this? How do you have a right to inspect this
Because
document?
section 74B, my lord,
Yes.
public records kept in any state or union territory of public documents,
Yes.
private documents. It comes under public documents, my lord. So the public officials have to produce to furnish the
No,
certificate.
see, read section 75. Every public officer having the custody of a public document, which any person has a right to inspect.
Yes. Being a news reporter, I have applied for certified copy
Now,
because
what is your right to inspect?
it's a public document, my lord.
Public document, that is not enough. You have to be a person who has a right to inspect.
To publish news articles regarding implementation of ICDS project under Sonai development. So however, petitioner infers that there has been huge level of corruption going on under both these blocks in the name of implementation of ICDS.
You apply under the RTA Act.
By section 75 also.
75 is for certified copy by a person who has a right to inspect.
I am being a reporter.
You may be a public spirited person. You take the information under the RTA Act. How do you invoke 75? 75 is only for certified copies of public documents.
Yes, public documents.
Yes.
It is a ICDS project comes under public documents.
Yes.
So they have to furnish the document.
And 75 you don't read in isolation. You read
But
76.
they have
This
accept-
certified copy can be admissible as evidence. That is the purpose.
they also,
This is not a provision for application of a certified copy. This is only provision how
but
do you
they-
treat a
they have
certified copy.
already accepted my application for furnishing the documents and they
Yes.
forwarded to the sector supervisor.
How do you come to a read court?
Page number 15, my lord. Kindly may.
You cannot come to, how do you come to a read court?
Lordship, may I connect now to the page 14, Lordships.
Page 14.
Lordship, that letter, Lordship, was issued by the Child Development Project Officer. Lordship, the subject kindly be seen. Forward,
RTI.
Lordship,
It is-
this is RTI. This is the
they
one
have
he has not
written-
applied for the RTI, Lordship.
No, I did not apply for RTI. Kindly
So
may.
how can my lord that
Page number 13 and 12, my lord. This is my application, page number 12 and 13. This is they written it, the RTI petition. I did not file under RTI petition, my lord. Page number 12 and 13 is my application.
See, 75 is not a provision to give you certified copies. 75 provides for certified copies of public documents.
My lord, the citation I have provided, in this citation, land related documents, but entertain in rate petition, para 9. Read court may enter.
Those are land related documents of that person who is interested in that land.
Yes, Lord, yes.
Now, how's your connection? You are a reporter.
Being a reporter,
You applied at the RTI, what is the difficulty?
Lordship, if we apply for as per the RTI, Lordship, that definitely will provide the that documents. No, you are not really,
Difficult.
Lordship.
What is your name?
Eke Hannan. I am appearing on behalf of K. Mira, my lord.
You are A.K. Hannan.
Yes, my lord.
Heard Sri A.K. Hannan Learned Counsel appearing on instruction of Sri K. Mira Learned Counsel for the petitioner. Full stop. Para. As per the facts projected, the petitioner is a news reporter of a weekly Bengali newspaper circulated in the Kachar district and had applied for certified copies of audit report, account report, receipt register, etc. from the Sonai ICDS project and Binna Kandi ICDS project in the district of Kachar on 14 to 2025. Full stop. such application has been said to be made under section 75 of the Bharatiya Takshya Adhiniyam 2023. Full stop. The grievance of the petitioner is that the information sought for has not been revealed, has not been given. Information and documents, / documents sought for have not been given. Para? Whether such information can be sought for by any person by invoking section 75 of the BSA 2023 would itself be a debatable issue, be that as it may. Issue when the avenue under the Right to Information Act is available, be that as it may, let notice be issued, returnable by 4 weeks. 3 J. Henry, Glen State Council accepts notice on behalf of all the respondents, who has also pointed out that in the communication dated 3/3/2025 issued by the CDPO Tona ICDS project, the action has been taken for under the RTI Act of 2005. Notices, notice returnable, extra copies. The maintainability of the writ petition is however kept open.
My lord, pendency is not a bar to punish the certified copy, maybe.
That will not say.
Obliged, sir.
May I please, your Lordship?
Yes.
Lordship, petitioners are landless persons and occupying selling surplus land at village Bamanpara Part 4 under Circle Bilasipara, Dhubri district. So, my lord, they have been occupying this particular plot of land, prospective plot of land, since from generations. And now the respondent authorities, especially Latmandal and circle officer, has visited their plots and without any serving notice, they have been given warning to vacate this plot of land. So in this case, and it is very imminent, they have apprehension that they may be evicted from this respective land. In this case, they have been paying revenue in regular manner.
Revenue means?
It is Kachapatta, this is, and
Kachapatta, you pay revenue?
Yes.
What kind of revenue?
I have, it is Jorimana, it is called. Yeah.
Those are not revenue. You are a council in the court.
Can you
Don't
find?
use terms so loosely that you are paying revenue.
No, my lord, can
You
you
should
find?
exactly disclose that these are Tozi Bahi. Tozi Bahi, these are fines.
It is page 31. Can you?
These are not revenue, these are fine for enforcement.
But,
Yes, what do you say? They are in possession for a long period of time.
And said
Hmm?
they have already applied for settlement also.
And why is the requirement? Is there any requirement of the land in question?
I have stated in para 4 that the landless person eviction was conducted in Bilasibara circle at it is Santuspara, Sarua Bakra and Chirakuti.
What is your name? Esidas?
Yes, Siddhas, my lord.
Hearts we Esidas Learned Counsel for the petitioners who have approached this court with an apprehension of eviction from their respective plots of land. First of, it is the projected case that such lands are under their possession since the days of their predecessors, and the officials had visited the land with an intention for eviction, full stop. It is also submitted that eviction is carried out in nearby areas. Let notice be issued, returnable by 4 weeks. Through J. Hendrick, State Council 1.
1, 2, 3 and 4.
1, 3 and 4, and Madam P.R. Mohanta for 2 extra copies. Sri Das, the learned counsel, prays for an interim order para. While which has been strenuously opposed by the learned counsel for the respondents. Full stop. It is considering the above, comma, while this court is not inclined to grant any blanket interim order, comma, it is provided that any action for eviction, if taken, has to be done by strictly following the mandate of law.
The mandate of law. Notice has not been served in this way.
Obliged.
May I please, your lordship?
Yes.
Lordship, this matter relates to cancellation of GST registration. Lordship, what has happened in this case? Lordship, so-called notice was issued to me for cancellation of my GST registration because I have not filed my return for the last 6 months.
Yes, we have dealt with some these matters.
Lordship.
Yes, can it be covered? Is it covered?
Yes, Lordship,
Have you given similar orders, madam?
Lordship, the similar orders I have annexed with the thing, but they are lots of judgments. Lordship, the judgment is there, which is annexed at page, Lordship.
No, there are orders
But-
passed by this court.
Yes, your Lordship, this court also has passed
Yes.
the orders.
Doctor,
Lordship, I'll give a
Gogol,
copy, he can verify.
if you are agreeing, then you can make the corrections, we can dispose of this matter.
Lordship.
Okay? Okay. Give a copy to and make the corrections in pencil and give it to our court master.
Yes, your
Okay. लिखिए लो, हाँ?
Lordship, the
And Havelia, Dr. B.N. Gogoi. You appear from, Dr. Gogoi appears for?
GST.
Yes, okay. Dispose of. The next one, similar.
No, Lordship, that is not cancellation of GST.
That is what?
Lordship, this is a this is a case, Lordship, wherein Lordship, the respondents have passed an order of Lordship adjudication order has been passed, assessment order. Lordship, the assessment order does not contain either signature. It has neither been signed nor been digitally signed. No reasons have been assigned in the order, and even DIN number has not been provided.
I think you can have the instructions.
Yes, sir.
These are. But if they overcome this, then what do you do, madam, on merits? Do you have a case?
Lordship, I am only pressing for remanding with the matter to because all over India, Lordship,
Okay, you take instructions.
different courts are there. Lordship.
Okay, and take instructions on Wednesday next. Okay.
Lordship.
Lordship,
Hard.
I may be protected till then.
The page
Wednesday-
58 is there, Lordship.
Huh?
Why you have been done, that is there.
Heard Miss Anne Havelia, learned counsel for the petitioner who is aggrieved by a demand order dated 10/2/2025 along with DRC 07 dated 10/2/2025 filed by the Assistant Commissioner CGST Guwahati Roman Capital 2 Division for the assessment year 2020-2021. Full stop. Para, amongst other grounds, comma, it has been urged that the impugned order does not bear any signature or
DIN number.
the DIN number. Full stop. Para.
Even the reasons have not been assigned. What is
It is also contended that no reasons have been disclosed in the said impugned order. Para. Dr. B.N. Gogoi, the learned standing counsel, CGST, prays for some time to obtain instructions.
Look.
Para. List for motion on Wednesday next. To facilitate Dr. Gogoi to have the instructions, let an extra copy of the writ petition be served upon him during the course of the day.
Deeply obliged.
interim?
Good. Wednesday, you are waiting since when? Interim impugned
Okay.
order is of February.
Lordship. Much obliged. Lordship, I will give the, so far as item number 11 is concerned, I will give the correction.
Yes, yes, but both of you have to give it together.
Yes.
Lord.
Lordship. Much obliged.
May I please, your lordship.
Yes,
Lordship, in this case, your lordship, my similar limited prayer, lordship, that one representation has been filed, the present petitioner's father's lordship.
One?
One representation has been filed, lordship, that is pays
representation regarding what?
lordship regarding correction of the record, land records, lordship, that is page 34. And ultimately, lordship, that petition has been forwarded to the DC, and that DC also forwarded to circle officers. And circle officers has been registered as a case number, and private respondent was called, but they did not appear. And that report has been submitted before this DC lordship. That
Yes, what do you say for cancellation of, for correction of mutation, correct the land records
then
by cancelling the names of the private respondent, that is the representation. Heard 3, I hoc learned counsel for the petitioner who is aggrieved by the inaction on the part of the respondent authorities to act on the representations which was filed for cancellation of the names of the private respondents and correction of land records pertaining to certain land. Full stop. The petitioner also claims to have procured a probate certificate on 28/20/2024 with regard to the payment of the compensation in a land acquisition proceeding and for recovery of the same from the respondent number 6. For those you have to approach a civil court, how do you recover through a writ proceeding? Para, let notice be issued, returnable by 6 weeks. Revenue Department, Madam PR Mohanta, 1,
Lordship, I appear on behalf of respondent 5 to 7 lordships.
2 also,
Oh, so 2 to 5 lordships.
2 to 5, 2 to 5, extra copies. 6, 7, 8, 9, registered post-PTAD steps within 2 days.
highly obliged.
আমাদের non-consideration of the representation গুলি বুঝতে পারি তো, আর আমরা কি agree by? Or petitions are agreed by? Okay, ঠিক আছে. Yes, next.
May I please, Lordship? Lordship, here, Lordship, this petitioner, Lordship, is the proprietor of a petrol pump, Lordship. And Lordship, what happened? Lordship may come to page 28, Lordship, Annex 7. He has the account in the State Bank of India, Lordship. And that account has been put on debit freeze, Lordship, only for an amount which was paid against petrol through Google Pay, Lordship.
Your
2,000
account has been freezed.
freeze, Lordship.
SBI, any counsel is there?
Lordship, I want to serve them copy, but they refuse.
So they are only panel counsel, they will not accept
The
notice.
notice should go, Lordship.
Heard 3, M. Ahmed,
Yes, Lord.
learned counsel for the petitioner who is aggrieved by the action of the State Bank of India in freezing the bank account of the petitioner maintained in its Mongoldoy branch. Full stop. The petitioner has been informed that such action has been taken on instructions of the Cyber Crime Police Station, Trichur City, Kerala, for credit of transaction amount of rupees 2,000 from the said account through Google Pay. Para. Let notice be issued. That cyber, you have not made a party. Why?
That's why I have not made them a party.
You have to make them party. State Bank will simply say that we have acted on the instruction. It however appears that the concerned investigating agency has not been made a party in this writ proceedings. Para. Sri Ahmed, Learned Counsel prays for and is granted a week's time to file application for implement of necessary parties. Then we'll issue notice. But do it soon. Why?
Okay, Lordship, I'll file it tomorrow.
Yeah, Chaudhary?
Thank you, Lordship. This matter is regarding the non-payment of the ex gratia amount given to the petitioners due to the date of the petitioner's father by the extremist, my lord. So under the extremist policy, my lord, some earmark has been 3 lakhs rupees has been earmarked for giving to the families of
When was the death?
my lord.
That was when?
Date 90.
Huh?
90.
Now, my lord, the
23,
23, my lord, he is the
1990, my lord. I have explained, my lord. In 1990, my lord, on the same day she was born. In 1990, my lord, in October, my lord, she was killed, and my lord, in the June, my lord, she was born, my lord.
Okay,
Then
then,
she was a breast suckling baby,
okay,
and she
then
could not do it. So
from
under that,
1990 to 2000, how many years? 10
1990,
years?
under that policy,
2010, 20 years.
my lord,
2020, 30 years. 2025, 35 years.
my lord, under that policy, my lord, under the initial policy, my lord, a job is, my lord, job is a must for the such family. But subsequently, that was repealed in 2004. And then, my lord, 2013, my lord, the second policy decision has been taken. Then, if anybody has applied subsequent to it, my lord, then 3 lakhs rupees to be given to the family members, my lord. 1 lakh has been given, my lord, and the balance 2 lakhs has not been given.
Where is your certificate that the death was in extremist violence?
My lord, the FIR we have said that.
My lord, there is nothing will annex, whether
But-
it is killed by
but-
the extremist or my lord, some other religion.
But my lord, I have got, my lord, of course, I have not annexed here. There's a communication given by the chief secretary and to the deputy commissioner, my lord, asking that the balance amount is to be, my lord. This
You bring that on
communication-
record, we can direct for at least issuance of notice. You bring that on record.
My lord.
File an
It is-
initial affidavit by the day after tomorrow, I'll have it on Monday.
It is only because of it is communication between the department.
We
of
want to have a look, that is the most important thing, which will have the foundation of your case. Simply saying that that was by extremist violence may not do. If there is a communication,
My lord.
you bring it on record.
When then, my lord, that representation was filed on 2021 and 2022.
Areas,
that, my lord, nothing has been, my lord.
my lord, some lexes were there because of the minority, my lord. Beers actually baby, my
You
lord.
became a major in the year when?
My lord, yes.
2008,
2010, my lord, CHN majority.
2008.
10, my lord,
Okay,
2010.
2010, then from 10 to 25, 15 years?
2010, my lord, some sorts of difficulty was arising because her mother was married and immediately thereafter, my lord, when her father was killed, my lord, and thereafter mother has been also expelled from the family member.
No, understood. From
So-
2010 to 2025, 15 years is a long time.
My lord, I do admit, my lord, I do admit. And that is why I am not, my lord, praying for the employment, my lord.
And there is no scope of employment
There is
under
no
the
scope, lord.
92 scheme. Third, Sri M.H. Chaudhary, Learned Senior Counsel, assisted by your name?
Mr. R. Borua.
R. Burwa for the petitioner, who by means of this application has prayed for release of ex gratia under the, within inverted comma, Assam Public Services within bracket, appointment of family members of persons killed by extremist oblique terrorist bracket close rules 1992. Full stop. The death, however, death
And
of the father of the petitioner, however, appears to be in the year 1990. Full stop. Sri Chaudhary, the Learned Senior Counsel, has on a specific query with regard to the on both the aspects of the latches of the delay in approaching the court as well as to make such a claim, Sri Chaudhary, the learned senior counsel, has submitted that there is a communication which would be relevant to answer the said queries. First of, since the said communication has not been annexed to the writ petition, this court grants time of how many days?
1 week time.
Grants a week's time to the petitioner to bring on record any such communication by way of an additional affidavit.
Well, highly opposed.
List for motion along with the additional affidavit that may be filed.
Highly opposed.
16.
May I please, Your Honor?
Yes, please.
Non-payment of proper compensation, Lordship, in land acquisition matter, Lordship. Lordship, I have also filed application under section 15 of the right to fair compensation and transparency in land acquisition, Lordship, but they have not considered the same, Lordship. What happened, Lordship, the father of the petitioner is.
Yes, what do you do in section 15? This land has been acquired under the Act of 2013.
Yes, Lordship, for Assam Mala project, Lordship.
How do you respond, Mr. Andy?
Let me take instruction regarding that, my lord.
Fair compensation. You submitted your objection within the time specified.
Yes, Lordship.
When was the preliminary notification published?
Lordship, on 15/11/2021, Lordship.
And your objection?
Lordship. Lordship, on 12/5/2025, I have application for proper compensation, Lordship.
That objection was not filed.
This is not an objection under section 15. Section 15 is an objection on the first preliminary aspect. When the preliminary notification is there, within a specified time of 60 days, you can raise an objection. That is not your objection.
No, Lordship.
You may be aggrieved by the adequacy of the compensation.
Yes, Lordship.
For that, you are not supposed to take recourse under 15.
Yes, sir.
You may take recourse under 64 for enhancement. Has any award been paid to you?
No, Lordship. Till now, not payment. It's made, Lordship. Only one
Has any assessment been made?
Yes, Lordship, but only Assam type house, Lordship. They have made an Assam type house, page 46, Lordship.
No. What is your name?
GG Gogoi.
Mr. Gogoi, see, those aspects would be within the realm of factual disputes, whether it's an Assam type house or RCC structure. For that, you have a remedy under section 64 to seek enhancement. You can say that it was a RCC structure which has not been properly assessed. It cannot be in a writ court. So that is why you're asking whether the assessment has been made or not. Maybe wrongly made.
No, Lordship.
No made, not made.
Not made.
No award paid. What is the stage? What is the stage of these proceedings?
Lordship, they have, I have submitted an application on the hearing also conduct, Lordship, on.
Now you have to have a specific grievance in coming to the court.
Yes, Lordship.
What is your grievance?
26/5/2025, they have conducted a hearing, Lordship, page
Yes.
44.
Thereafter,
I have also submitted an application, they have issued a impugn resurvey order, Lordship, on 4/7/2025, Lordship.
then what has happened?
Lordship, then I have approached the petition, I will go, Lordship.
Mr. Handik, we don't find any cause of action arising as a you take instructions.
Lordship.
Third, Sri GG Gogoi Learned Counsel for the petitioner, who has approved this court with regard to compensation for acquisition of land for the Assam Mala. Full stop. It is contended that the your father is there or not?
Yes, they are.
Then he has not come.
He has not come. See,
Why?
he's older than Lordship.
No, he's
I'm
not
running the-
required to come.
There is an agreement, my lord, between the parties, not with their, my lord.
Your father has to be the party. You can represent him you can file the affidavit.
An entire application submitted by me, Lordship.
It is the case of the petitioner that the father of the petitioner is the recorded pattadar of the plot of land which has been acquired for the said project. It is also contended that the land was developed and an RCC house within bracket G+1 was constructed from which a grocery shop was being run. Better? So we Hendrik, the learned state council, however, submits that no clear cause of action appears to have been made out for approaching this court. Para, be that as it may, let instructions be obtained by Sri Hendrik, the learned state council, on the status of the land acquisition proceeding, which was initiated for the acquisition of the land in question. List this case on yes, on 15th of. No, then we can issue notice unless be that as it may, that notice be issued returnable on 15th of October 2025. Ms. P.R. Mohanta for one. Then PWD, K. Borthakur on behalf of PNAC 2. And District Commissioner J. Hendrik, State Council 3, 4, 5, 6.
And 6.
Extra copies within 2 days. Okay.
May I please, your lordship? In this case, your lordship, on 15/1/2025, your lordship, son of the petitioner had expired as a victim of murder, your lordship. And after the untoward incident, your lordship, petitioner submitted an application before the District Legal Service Authority, Kamrup Metro, your lordship. And that has been pending, your lordship.
Yes, madam, you'll be appearing.
Lordships only for respondent number 2.
This number?
Only for respondent number 2, your lordships.
2.
Yes, your lordship.
Who's the authority who will take a call?
The DLSA, your lordships, respondent numbers 3 and 4. No, not 4, just
Only
3.
Through DLSA, is there any standing
Yes.
council?
No, they are represented by the government advocate.
Yes.
The-
We issue notice at this
Yes,
stage,
Your
then. Heard Sri S.I. Akand Learned Counsel for the petitioner, who by means of this application has made a claim for payment of victim compensation under the Assam Victim Compensation Scheme dated 18/10/2012 as amended on 1/2/2019. Full stop. It is the case of the petitioner that her son was murdered on 14/1/2025. And in that connection, Dispur PS case number 26/2025 has been registered.
NBS तो NBS लिखी BNS हो जाएगा.
Yes. What is this new act?
Typographical error, your lordship, BNS.
Registered. Let us not go into those aspects then. That notice be issued, returnable by 6 weeks. Sri J. Hendrik Learned State Council accepts notice on 1, 3, and 4, whereas Ms. R. S. Chaudhary, Learned Standing Council, Asalsa, is present for the respondent number 2. That extra copies be served upon the learned counsel for the respondents within 2 days.
So blessed.
Obliged.
Just a minute, Mr. Akand. Mr. Akand. Pendency shall not be a bar for consideration and disposal of the representation in this regard.
I'm so blessed.
Lordship, kindly may allow the petitioner to withdraw this petition.
Why do you want to withdraw?
Lordship, there is some erroneous.
Okay.
repetition.
3S Bourbon Learned Counsel for the petitioner submits that due to inadvertence, some error has crept in in presenting the petition, and he accordingly prays for withdrawal of the same with liberty. Good stuff. Also heard 3J Hendrick Learned State Counsel, who does not object to the said rare para. Accordingly, this writ petition is dismissed on withdrawal with liberty as prayed for.
Obliged.
Mr. Gupta, Mishra. Gupta, Mishra, where are you? It's not you, Gupta. Some other Gupta. Yes, normally they are present in the court where has happened. AK Gupta, RS Mishra, by order. Mention was made of this matter. Huh?
I have seen, my lord.
And income tax. Who is there for income tax? Chitia. SC Kyle.
Can we pass up order timing, my lord? I will.
Okay, well, after some time. What is 3? Mr. Roy?
My lord, the petitioner, he purchased a plot of land measuring 3 kathas, lordship. And then your lordship, almost in 2003, the petitioner come to know that 2019, lordship, that it is a land is declared ceiling surplus under the Urban Land Ceiling Act 1976, lordship. But never the position of the land was taken by the government, nor any compensation was paid, and no any notice was issued to the petitioner. In the meantime, thereafter, lordship, by a repeal act of 99, the Urban Land Ceiling Act was repealed, lordship. And accordingly, the Assam government has also issued a gazette notification that the
initial ceiling surplus was declared under which act? 56 Act?
No, Urban Land Ceiling Act, ULC Act, 1976. And there are lordship, many Supreme Court judgments and High Court judgments. Lordship, when the ULC Act was repealed in 99, there are leading judgments from this point by the Apex Court and as well as, my lord, the different High Court that if the position was not taken by the government, the petitioner will have the right to enjoy having or right in this.
Now, what is your grievance?
Given simply, lordship, because when I applied for mutation of my name, lordship, it was not done. And the government has suggested that you apply for settlement of the land. If I apply for settlement, lordship, I will have to pay the heavy premium. She is a widow lady, 82 years old, lordship. And she is under the
initial purchase was by a registered sale deed.
Yes, I have an 1982.
Yes, what do you say, Mr. Tricky issue. Because at that time when the purchase was made, that was not a valid purchase.
Lordship.
The Act of 1976 had already taken into.
Well, the Lordship Act applies only in case of vacant land. I had constructed my house in 1975. It does not apply when there is a house, lordship. I have quoted the.
Now, what do you want in this petition?
This, Lordship, only that petition can be disposed of, that the petitioner, respondent may consider my application and mutate the name if I am entitled as per.
That can't be disposed of. We'll have to take.
Then notice.
Let me
notice
Notice free SP Roy, Learned Counsel for the petitioner. Full stop. It is the projected case that a plot of land was purchased by the petitioner by registered sale executed in the year 1982. Full stop. However, the possession of the said land has been stated to be from 1975. Full stop. The said land, however, was part of the was declared ceiling surplus under the Urban Land within bracket Ceiling and Regulation bracket close Acts of 1976, which, however, was repealed in the year 1999 with effect from 6/8/2003.
In Assam.
Full stop. The grievance of the petitioner is that in spite of such repeal, the petitioner has not been given the benefits of being the owner of the land in question in many respects. In land in question. Let notice be issued, returnable by 4 weeks.
Okay.
Miss G. Hazarika for 1.
1 and 4.
1 and 4 also, okay. 2, 3, 5.
Lord, 2, 3 and 5.
Yes, extra copies be served by tomorrow.
Till then, no courtship action.
What course of action? Is there any apprehension? What is your apprehension?
Lady,
You are in possession. What is your apprehension?
okay.
Yes. You to get the instruction and try to dispose this of the return. Motion bill. Okay.
My lord, this matter, my lord, we are aggrieved by the, my lord, ongoing construction. My lord, there is an IOCL terminal, my lord, which is a protected area. My lord, just.
Where is GMDA? GMDA?
IOCL.
I'm being told he's coming on the. He's coming. Okay, we'll issue notice at this stage. We wanted your presence. They said it is within the protected area. And if that contention is correct, then construction will not be, you cannot have a construction.
But
This is not a new construction, it's the construction of 5 years old. From 19, it has been going on. Already been completed. Mr. Bora? If it is a protected area, within the protected area,
Lord, it's a protected area, tag number pattern is given. And when the construction is being carried out, it's a different tag number pattern number.
No, my lord, the building construction is not within the protected area. It is near the, my lord, protected area, just within 100 meters, my lord.
so is there any restriction?
My lord, under the law, my lord, what I have seen, my lord, I have checked, my lord, that, my lord, there is no law providing for buffer zone, my lord, between a refinery and construction. There is no law as such, my lord, but our concern is safety, my lord. The safety of the refinery and also the safety of the public, the residents who would be coming, my lord. The construction is ongoing. The occupation of the flats have not been taken place. Our only concern is, my lord, the safety, which was ignored.
No, your approach to a writ code has to be on the basis of some foundation, some plank has to be there. Where do you get the right? You have pointed out that there is no law regarding retaining of a buffer zone.
My lord.
Unlike refineries, others. What is this? This is what kind of, this is a storage facility.
Storage facilities, my lord, my lord, huge amount of petroleum products are stored. and entire northeast supplies are.
There would be some literature, how do you maintain? You come up, you may have a case, we are concerned about your
No, our
approach.
primary concern was, my lord, when the building permissions were given, it was the duty of the builder to, my lord, apprise the planning authorities, JMDA, GMC, about the fact that near the vicinity of the building, there is a
No,
refinery.
there is no restriction in law.
My
Then
lord,
where is the requirement to apprise them? There has to be a restriction in law.
my lord.
That is heard.
And my lord, I am relying on one judgment if I am allowed to place, my lord.
Now we'll issue notice at this stage. You have Hertz Free H. Gupta, learned counsel for the petitioners. For the
11.
petition number 1 is the Indian Oil Corporation Limited. And the grievance of the petitioners are with regard to the construction of a multi-storied building adjacent to the boundary wall of the IOCL Guwahati Terminal Batkuchi. Full stop. It is contended that the terminal is a protected area under the Assam Maintenance of Public Order Act 1947 and construction of a multi-storied building in the vicinity, amongst others, would be a safety concern for both the residents as well as the refinery. That notice we should returnable by 6 weeks. Three forest. D Gogoi for 5. District Commissioner, State Council. You'll take? For PCB also?
Yes.
Then let somebody else take for the. Mr. Nath. Sri D. Nath, Leonard Sinego advocate for 6.
I am for 7 and 8, my lord.
Sri S. Bora Standing Council, GMC, GMD for 6 and 7 and 8.
6 and 9.
6 and 9. 6 and 9, D. Nath.
Dot.
Then 10, G. Hazarika 10. 11 PCB Standing Council S. Burwa.
No, 10,
11 and 12.
10, 11.
11 and 13, D. Nath, you will also take for 13 also.
There is 2 teams.
Yes, 13.
13 also, huh? D. Nath,
Numbering
13.
is wrong.
Number here it is correct.
Lot.
And 11 and 12,
11.
as Burwa, Standing Council PCB. Okay, extra copies.
No,
We have a returnable date.
no.
Returnable date, ऊपर लिख दीजिए, returnable on 17th of October.
Can I bring note that the pendency will not be barred because we have given several representations to
For
GMD authorities to consider our grievance, my lord, to address the issue of security and safety concern. At least, my lord, they could have arranged for a meeting and we could have discussed. All the authorities could have sit together and discussed, my lord, how to prevent any safety and security concern in future.
That will not end the matter.
My lord.
Let them fight the returns.
My lord.
1 to 4 is supposed to be ready.
The private respondent,
Private respondent.
1 to 4.
1 to 4, my lord.
Is supposed to be. Kept it included. Extra copies before the.
Lots of registry may be directed to reflect my name.
The cause list to reflect the names of the learned standing council of the respondents.
PCB specifically.
Everyone.
I'm extremely sorry. I was in port number 2 on legs. Sorry, my lord.
Your colleague was also not there.
Yes, I'm sorry. Yes, Lord. Yes,
Yes, what? Covered again.
No, it's not covered, my lord. It is against recovery of the income tax proceeding, my lord. What happened, my lord? In 2023, my lord, 18/3/2023, assessment order was passed against the petitioner, my lord. For the assessment year 2015-16, against that petitioner preferred an appeal, my lord. Appeal was pending. Now, for the subsequent assessment year, another order was passed, my lord. So he could not prefer the appeal. In the meantime, recovery was initiated. After initiation of recovery proceeding, he came to know about passing of the order. He preferred an appeal. Now, in both the appeals, my lord, hearing has been concluded, it is awaited for judgment. In the meantime, since recovery has already been initiated, my bank account has been freezed, my lord. I am paying for my.
You take the decision, then you take the action.
What's the problem is this is a faceless appeal. The
No, you
appeal-
decide, you dismiss the appeal.
No, Lordship, my problem is this, Lordship, we cannot locate where it is pending. Because it
faceless
is
proceeding.
implied faceless.
My lord,
Faceless or headless
Both, Lordship.
or bodiless?
Lordship,
Have you
this-
filed the appeal actually?
file is,
Yeah,
yes, my
yes,
file is there.
it is
appeal is
there.
there.
They have submitted some document.
You can retrieve the appeal. That is not a problem for you. They
Lordship-
can, we can ask them to give another copy of the appeal. You
No,
have
it
it,
is
No, Lordship, that is not the
Then-
question, Lordship.
No,
Now to take instruction from from where I will take instruction, that is difficult. Lordship, I
No,
talked
but
to,
that will not be proper. Before taking a decision, if you go for recovery, you dismiss the appeal.
no, Lordship, what happened, they referred the appeal with some delay. And the appeal.
You can dismiss the appeal on the ground of delay.
No, Lordship, that probably that was, I don't know, the appeal was heard on merit also. No,
Take a decision. You, is there is no,
Lordship, then Lordship.
there is no restriction for you to dismiss the appeal, but you have to assign ground.
No, definitely.
But without considering the appeal, if you go ahead, the
No,
appeal
Lordship,
would
that was previously, before filing appeal, the proceeding, recovery proceeding was initiated.
recovery proceeding initiated when?
Lordship, it was.
What is the
initiated-
stage now?
Lordship, bank account has been freezed.
And hearing has been concluded, my lord, awaiting order, my lord.
And
We have-
Lordship, that account was freezed before filing appeal.
Oh.
my lord, there were two.
When the account was freezed when? Frozen
Lots.
when?
And
It was on 19 to 2025, my lord.
19 to 25, bank
Account was frozen, my lord.
account frozen.
My lord.
And the appeal filed when?
The appeal was filed on 2nd of April 2025.
Oh,
But there is one thing, there are two assessment here, my lord. First appeal was filed within time, my lord. Now recovery is for both the assessment here, my lord. First appeal was filed within time, my lord. It was filed in 2023. Same has not been decided yet, my lord. Lordship,
now
it's the-
what is your prayer, Mr. Mishra?
No, I'm praying for defreezing my bank account because my business has been stopped, my lord. I've not been able to operate anything, my lord.
Bank frozen when?
My lord, it was
February.
February, my lord. Appeal was preferred in, my lord,
February,
April.
we're in as end of almost mid of September.
So hearing was completed in 2025, May, my lord. Hearing was concluded in 12/5/2025.
Yes,
my
you
lord.
come up with instructions.
Lordship, maybe taken on Wednesday. Lordship.
Friday, Lordship.
Huh? Next Friday is not possible.
This Friday,
This Friday, we can have it on Monday also.
Tuesday, Lordship.
Tuesday.
my lord.
Tuesday, okay. Heard Sri R.S. Misra, Learned Counsel for the petitioner who is aggrieved by the action of the respondents in freezing the bank account of the petitioner. Full stop. It is the case of the petitioner that for certain actions, two appeals have been preferred, which are pending consideration. Full stop. Though one of the appeal has been preferred after the action of freezing the bank account has been done, the other appeal was preferred in time and before disposal of the, and without even disposal of the, without even passing final orders on the appeals, the impugned action has been taken. Para 3 SCK, Learned Senior Standing Counsel, Income Tax Department.
Lordship.
Prays for some time to obtain the instructions. Para list for motion on Wednesday to facilitate Sri Kyle to have the instructions. Let an extra copy of the writ petition be served upon him during the course of the day.
Much obliged, Lordship. Deeply obliged.
Oh.
16 matters.
Well, in item 20, I have some instructions. The inhabitants of these are forest dwellers of my lords Dibru Soikwa. Government has identified a different plot of land in Dibrugarh district. Stakeholders meeting was also conducted. So they are identifying the land and also the genuineness of the claims, my lords. This is the,
No, but 16 matter, it cannot go on like this.
yes, my lords. We understand, my lords, but it is being expedited now, my lords. DC Dibrugarh is in communication with DC Tinsukia.
What is, Mr. Abba, what is the present status now?
of your occupation over the plot of land?
Lordship.
What is the
Yeah,
status? Are you still occupying the land in question?
Lordship, our grievance is that we have to be shifted. They issued the government, but instead of that, the area has been declared as the now it has been national park now.
No, that is okay.
Yes.
But what is the status? Are you still in possession of the land in question?
No, they are still living there. They have no any status now. Only their status is their citizen. They are casting vote. They have been.
That is not the question. The original land which
Yes,
is
yes,
under your
yes,
possession.
yes.
Are you still staying there?
Yes, still
you are staying there.
Yes.
Mr. Gogoi, there is no interim
My lord,
order.
my lords, we know, but what has happened, my lord, the lordship will find it in annexures under the.
Yes.
What has happened, my lord, original LOT was a different figure. Now it has inflated to a very large figure. So the land which you are, forest department cannot have land, my lord. Revenue is identifying lands. We need 177 bighas, my lords. That has been identified. So that process is on, my lord.
But their status as forest dwellers have been recognized under the FRA Act of 2006.
No, that has not been done because they are protected by the forest village rules, my lords. They are forest villages of by dint of 1891 regulations, my lords.
Okay.
18 Assam Forest Regulation 1891.
Their status has been recognized.
Yes, they are forest villages. We have admitted that position, my lord. But we are checking the genuineness because for assuming well, the original figure was something, it is inflated to a very large extent.
No, this does not go as a certification is not given en masse. It is given on a case-to-case basis.
Yes, that is also been verified, my lords.
So when we close this, you complete this process within.
My lords will keep it open. Otherwise, my lords.
No, 16 matter we cannot afford to.
I'll leave it to you.
We have this on record, and we say that the steps are being taken, identified, complete the process within a period of outer limit of 90 days, 3 months. Okay.
Well,
Heard.
Well, that has to come from revenue, my lord. That land is revenue.
Revenue department.
Yes, Lordship, at the project, at the price places, forest has given the proposal for rehabilitation to the government.
Yes, that we have
That
seen.
is the status.
That we have seen.
But government is doing nothing. The last time the learned council of the government took time for instruction.
In this case, Lordship, we made party, but our name is not reflected, Lordship. I'm not ever actually. 2016 matter. And
Even they have formed a committee, my lords. That committee has also been asked to visit the place and see if it's tenable for them or not.
We'll have this tomorrow.
My
for
lords.
disposal.
My lords.
Okay. We'll have it tomorrow. Mr. Rabha, please come tomorrow. Okay. Heard
Lords,
Sri UC Rabha, learned counsel for the petitioner. Also heard Sri D. Gogoi, the learned standing counsel forest department. First up, Miss G. Hazarika, learned standing counsel revenue, and Sri J. Hendrik, learned state counsel are also present. Para. Sri Gogoi, the learned standing counsel forest department has submitted that as per the latest instructions dated 8/9/2025, an alternative plot of land has been identified for rehabilitation of the petitioners who are forest dwellers.
Forest villagers, my lord.
Forest villagers. Full stop, Para. On the request made by the learned council, the consideration of this matter is deferred till tomorrow, when an endeavor will be made to dispose of the matter as the same is pending since the year 2016. Yes, tomorrow.
Problem.
our name may be reflected in the copy.
You are aware, madam, the names of standing council revenue be reflected in the cause list. You make extra copies of this.
My lords.
I'll
I'll provide
be
you my-
appearing in this. We'll have it tomorrow for disposal.
Lot.
There is some alternative area being identified.
Yes, some identity.
You also go through these instructions. We'll
I
have
have
it.
seen. I have seen.
Lordship, I keep that in record. I'll provide them, my lord.
You have it.
I have a copy. I have copies.
Lordship.
Yes, next. Yes, Mr. Sinha.
Well, here the petitioners are in possession and occupation of land measuring 31.59 acres in Karimganj district under Nilambazar Revenue Circle. But subsequently, the petitioner has come to know when a fishery was settled in favor of respondent number 7, that some of their land has been settled under the fishery. Tapan Kumar Das, that is your lordship will find annexure page 60. madam. Some portion of land has been included in this bill, this fishery. When their my lord men have encroached over the land of the petitioner.
Yes, have you acted on the representation?
My lord,
They have claimed that a detailed representation was
no, lordship, in this case, lordship, we file our affidavit. In affidavit, lordship, we have
Yes.
that will not serve the purpose until the deputy commissioner hear the matter, along with the calling upon the petitioners. Because it is a land since 1800 and something, my lord, they are occupying. And also they
You can
presently.
direct the deputy commissioner to give a hearing to the
Lord,
stakeholders.
yes, my lord, that will be better, my lord.
But the private respondents have appeared.
The private respondent, there is a fishery department, man. They have settled some
What
portion of land.
about this Topondas?
Topon Das, my lord, that is fishery, that settlement holder, man.
No,
Even
he's
the-
not a party here.
His party here.
So that is what we're asking. Where is the private respondent?
Yes, my lord. She is not appearing in this case, man. I don't know. Till date, they did not appear, man.
But did you serve?
Yes, my lord. I think it is served.
Where have you served?
Visa Hussain. Visa Hussain. Oh, they were both in the perform. I don't need to say which of
Yes, what do you say? Can we dispose this off?
Yes, not
Heard Sri B. Sinha,
very hard. Yes, yes, my
Learned Counsel for the petitioners.
Yes, yes, you are good.
Also heard Sri J. Hendricks, Learned State Counsel, as well as Miss G. Hazarika, Learned Standing Counsel for the Revenue Department. Para. Office note dated 14/9/2023 reflects that service upon the respondent number 7 is complete. Para. It is the case of the petitioners that a plot of land
.31 acres in fifth line, madam, sixth line of synopsis.
Not 31, this is 111 by 3/4 cadres.
Cadres, madam.
Yes.
This is a
plot of land,
old measuring.
measuring 31.59 acres was purchased by the predecessors of the petitioners by registered sale deeds Full stop. The said lands were being peacefully possessed. Oh no, said lands were under the peaceful possession of the petitioners since the time of their predecessors. Full stop. In the meantime, comma, an area of 900 hectares has been settled in the name of the shown SHON, देख लीजिए ना, Beal, BWL, Mean, Mahal. In favor of the response number 7 by a communication dated 30/8/2022 issued by the Managing Director, AFDC. Whereafter, the agents of the response number 7 are trying to trespass over the lands of the petitioners. Full stop. It is the specific case of the petitioners that their lands have been wrongly included in the land settled in favor of the response number 7. Full stop. The petitioners has also Sri also learned counsel for the petitioners has submitted that a detailed representation dated 8/11/2022. Is it 8/11?
Yes,
has been submitted before the concerned District Commissioner Karimganj, which has not been considered. Full stop. Para. Sri Jahandik Learned Council, Learned State Council has submitted that since the dispute would be in the realm of actual dispute, comma, this court in exercise of jurisdiction under Article 226 of the Constitution of India may not have the expertise to give a definite finding. Full stop. He, however, is not opposed to a direction to the District Commissioner Karimganj to look into the matter and dispose of the representation in accordance with law. The aforesaid submission is also endorsed by the Learned Council for the other official respondents. Para? This court has noted that the petitioners have submitted a detailed representation before the Deputy Commissioner Karim is now Sri Bhumi, Sri Bhumi on 8/11/2022, and there are no materials on record to show that the aforesaid representation has been considered the affidavit in opposition filed by the respondent 3 on 14/11/2023 has, however, denied
Paragraph number 5, Lord.
Paragraph 5, my lord, is old document that says, last line, my lord. Taluk detail mentioned.
Has about denied the rights of the petitioner. Under that, where is the scope of further representation disposal?
Lordship.
This was not pointed out. This circle officer is categorically said.
Lordship. And the paragraph 8 also, my lord, we have.
But this also my.
Then you have to approach the civil court.
No, no, of course, my lord, but let them come to a finding, my lord, whether we are, because if the Now, okay.
On consideration of the same comma, this court is of the opinion that a direction be issued directing the district commissioner Sri Bhumi to take on board the representation dated ... Abhi dekha tha, and dispose of the same by a speaking order. While doing so, the stakeholders, the petitioners, including petitioner and the other stakeholders, be given a personal hearing.
Yeah.
Full stop. Such exercise be undertaken and completed within undertaken and completed expeditiously and preferably within an outer limit of 4 months from today.
Oblige me. Hello.
Yes.
Lordship, kindly pass over this matter for detail, senior counsel.
Yeah, for whom?
And for respondent number 10 and 11, Lordship.
Who are 10 and 11?
10 and 11, Lordship.
Who are 10 and 11? Private respondents.
Private respondents. They are the complainants, Lordship.
Have you filed affidavit?
Yes, Lordship.
You have filed?
Yes, Lordship.
When did you file?
1st May of 24.
Your affidavit is not on record. You have been served, Mr. Hussain. Served copies or not?
They may be
Hmm?
directed.
You have been served or not? Mr. Bodloy?
No, sir, I have not been served.
Where is the copy? You have a draft copy, madam? Perhaps you, it's not the wakalatnama. We are asking about the affidavit of position. Have you filed?
Lordship, the affidavit was filed on 1st May of 24.
Let's check whether it is got a draft. We have a copy? 1st May 20? 1st May of what?
First May filed by respondent number 5, that is ARCS.
That hasn't
There
filed.
is ARCS, there is respondent number 5.
That is on record, Lordship.
It is on record.
Oh.
I agree with
Will you like to file affidavit, madam? That is what we are asking you. Here for respondent numbers
10 and 11.
10 and 11. What about 12? 12, who is appearing?
12 served, Lordship. They did not appear, Lordship. There are joint complaint by the 10, 11 and 12, Lordship,
Okay.
on which my nomination was rejected. Subsequently, Lordship, stayed by this honorable court. I am continuing, Lordship.
There is no finding on 12. Yes. This is Mr. Chaudhary. JMA Chaudhary has appeared for 12. Okay. 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 Yes, you'd like to file affidavit?
Yes, Lord.
What is your name?
Miss P. Das Lordship on
P?
behalf of Mr. K. Burwa.
On behalf of K. Barua.
Yes, Lord.
Heard. This is item number
20.
heard Sri M. K. Hussain, learned counsel for the petitioner. Also heard Sri G. Bodula, learned standing counsel, Cooperation Department, who has submitted that on 1/5/2024, the affidavit in opposition has been filed. Para, Ms. Fidas, learned counsel appearing for the respond numbers 10 and 11. Praised for and is granted 3 weeks' time to file affidavit in opposition. Please after 3 weeks.
Interim my contract, Lordship.
Is there an interim order?
Lordship.
Interim order passed earlier to continue till the next date of listing. All right. 24. 24.
May I please open? I may be allowed to withdraw this petition, my lord. Matter has become infructuous.
Yes, we have paid already.
You are P. Bora.
UK data.
You are UK Deca. Heard Sri UK Deca learned counsel for the. Sri UK Deca learned counsel for the petitioner submits that by flux of time, the matter has become infructuous. Also heard Sri C. Barua, learned
5, 6, 7, 8, and 9.
standing counsel, NHIDCL,
My lord, 5 to 9.
comma, Sri J. Hendik, learned state counsel, and Miss P. R. Mohanto, learned standing counsel, Revenue Department, who do not object to the prayer for withdrawal of the para in view of the aforesaid submission, comma. So aforesaid situation, writ petition is dismissed as infructuous.
Obliged.
25.
May it please, your lordship.
My lord, in
Yes.
this case, I have filed that IA.
This
That IA may
petition,
kindly be taken up first.
I for?
I have for dismissal of
For
the
dismissal
petition.
of
my lord.
the writ petition, because here-
I for dismissal of writ petition.
My lord, what happened? The subsequent development took place, my lord, as a result, the order which they sought to get implemented through the court, that order is no longer in existence, my lord. Here what happened, the mayor passed the order, my lord. And that order, my lord, they want to-
18/1/24.
my lord. Your lordship will take up that. I am for the respondent number 7 to 10.
18/1/24 has gone now. So where is the cause of action existing?
My lord, actually for filing this IA, the private respondent has not even the location because they are stating about decision of the GMC, my lord, but GMC has not filed that IA, my lord.
No,
The-
That is
see,
technical.
My lord,
see,
I have
those
to
are all
file
technical
objection, my
matters.
lord.
If you are aware that subsequently on 12/3/2025, a decision has been taken to revoke the earlier order of 18/1/2024. So how do you maintain the writ petition?
My lord, that is their submission. We have to file objection in this regard, my lord.
No, are you aware that?
No, my lord.
Thomas-
No, my lord. We are not aware, my lord.
Yes, Mr. Bora?
My instruction that this order hasn't passed, my lord. After the mayor and council is taken into consideration, everything, my lord,
12/3/25 has been passed.
it hasn't passed, my lord.
Then
Then, my lord, the GMC has to communicate us, my lord.
it
But
is on
nothing has been
record.
communicated,
It is
my
on
lord.
record. The GMC is endorsing this.
Yes, your
If
lordship.
GMC is saying that no, we have not passed, matter would have been different. It is on record. If you want, you can challenge this in a separate writ proceeding. If you are aggrieved.
My lord,
Where is that order? Which page?
my lord, in this regard, let me file objection, my lord.
In the IA, it is page number 15 and 15.
15.
15 and
15,
16.
16.
Date
25, 2025.
25.
25.
28th of May, 2025.
28, no, 20.
20.
28, 20. My lord, let me file a objection. My lord,
No,
thereafter, proceed my.
Mr. Saikia, you can file objection, but that will not improve your matter. We can grant you liberty to challenge this.
Uh,
If a subsequent order has been passed, revoking or recalling the earlier order, which was the subject matter of challenge. That has gone now.
That is correct, my lord, but thing is that, my lord, we have not aware about that order, my lord. It has filed by the private respondent, my lord. The GMC should have communicated to us if they have set aside some
Mr.
order.
Saikia, we do not
earlier.
have time to hear this kind of submissions.
Yes,
You are
my lord,
not
that's why,
aware.
my lord.
Now
Let
you are
me-
aware.
Yes, my lord.
And
Now
this is
you are.
endorsed by the GMC authority. That is what we are trying to impress upon you.
Yes, my
If
lord.
this was denied by GMC that we had not passed an order, matter would have been different.
Yes, my lord.
GMC is before us. You are aware with an order.
Let me take instruction, my lord.
When? Day after tomorrow.
My lord.
Day after tomorrow. Review by the learned counsel for the applicant. Respond number
7 to 10.
7 to 10 has submitted that during the pendency of this writ petition, an order dated 25/2025 has been passed by the additional commissioner GMC pursuant to a decision of the 16th general meeting, whereby the earlier order dated 18/1/2024 passed by the mayor in council has been recalled. What?
Actually modified.
Has been modified.
Modified.
Has been modified. Full stop. Sri Saikia, the learned counsel for the opposite party writ petitioner, prays for some time to obtain the instructions
Yes, my lord.
on the future course of action. Para list on the list day after tomorrow.
Oblige, your lordship.
Obliged.
Opposite party writ petition at applicants, sir.
Oblige, your lordship.
Yes. You have this copy of the order. It's part of the IA. You can discuss, get instructions.
Yes, sir.
Can it be after some time, my lord? My colleague will be there along with me, our board Pujari. After some time, my lord, we'll be there.
What is the matter, Mr. Das?
This is, we are the bank, Punjab National Bank. And there is some few gardens which belong to Assam Tea Corporation Limited. Now they decided by an RFP, they decided to lease out few of the gardens. Now our garden, which we have given on a loan in respect of two gardens, the Sipsagar packet they call it. Two gardens were leased out. Now, while leasing out, there was an agreement between ATCL and between the lessee. We are not a party, but there was also the fact on the RFP that you have to take a financial help from institution, any financial institution. But the ground is that our upfront money has to be paid to the ATCL. Upfront money has to be paid to ATCL for leasing out. Now, lessee approached us. We paid about 6.4 crores we paid.
Loan
to the lessee. But somehow he could run it for 1.5 years. Then thereafter he could not, because there was an attachment which is issued by the Provident Fund. They could not pay the amount, the PF dues. And ultimately the ATCL also, they have put it for auction. PF authority has put for auction. And this garden was sold. This garden was sold. Maybe the ATCL should have come to the court for protecting these two gardens. It is their property. They could not protect it. So now they said these are all wild elephants. So we cannot protect this garden. It is their property. They should have protect this. The land, everything.
Now, what is your grievance?
Now my grievance is that you sold it for auction. There is no problem. PF dues. But rest of the amount, being a public money, you should pay back to us. That's our case.
How much is the amount? How much is the amount recovered?
Recover is 8 point something. 8.8.
How much was your due?
Our dues were, PF dues were 74,44,286. Now, my lord, the balance in both the gardens are approx 4.5 crores. Balance is left of both the gardens.
But for you to be balance
It's
due to you.
After deducting, now 4.5 lakhs is there.
4.5 crores.
4 crores, I'm sorry. Is there.
Today, one small prayer, my lord.
even, my lord, in the earlier occasion also, my lord, now, my lord, puja is there, my lord. That bonus is to be paid for the, my lord, year 2024. Prior part, my lord, not the new liability. That we have filed an affidavit,
You
small
are for
amount.
whom?
My lord, I am for the Tea Corporation Limited, my lord.
ETC.
Yes. Now, in fact, my lord, the Provident Fund authorities, they are now, my lord, writing letters to us to, my lord.
You're
release-
the auction purchaser or what?
No.
No.
We are the,
Yes,
my lord,
Lord.
main owner of the, my lord, tea state, Assam Tea Corporation Limited. The tea state was of the ATCL. It was leased out to the respondent number 5. But we
Who is
didn't.
5?
5 we have served notice, he's
He's
not
a
coming.
leasing, he's a leasing.
Let's see your turn.
He, my lord, failed to make the payments and all, including Provident
They
Fund.
are 7.
Then the property was attached by the Provident Fund authorities and it was put on auction sale and it was sold. Now that from that the auction proceed, at
So
least
who's the purchaser now?
purchaser is not a party here in my lord. That party, third party right has been, my lord, already created. It is not they are not a party in the present proceeding.
During the pendency, we have nothing to do
But
with.
Mr. Das may be correct in contending that they are more interested in the money recovery.
Yes.
They are not.
I understand, my
Now
lord.
the
They-
extra auction amount, he is not even agreed by what amount the auction has fetched.
My lord.
He is only saying that pro rata basis or whatever is the basis.
No,
He
that's
is-
my lord, the terms of lease deed as well as the terms of agreement, what the petitioner had bank had with the respondent of 5, that they will have to place. That agreement, my lord, what agreement?
Have you disclosed that?
That,
in
my
your-
lord, agreement
Yes,
is
yes,
not-
everything
my lord,
is-
that agreement is not a part of the.
Everything is on record.
The
What
agreement
we-
is not a part of the petition.
No, what, it is part of the
Loan agreement.
agreement. No. It is there.
And today, my
Agreement.
lord, may I just,
Yeah.
one thing, my lord, I am praying, my lord, short prayer, my lord. So far as the, my lord, bonus liability is concerned, if that amount is released, my lord, from that particular whatever amount is lying with the, my lord, Provident Fund authority. In fact, they are now demanding that we should immediately release it. Hardly, my lord, lordship will see the affidavits, short affidavits I have filed.
No, the new incumbent has paid for such a direction.
No. Till the day when it was sold, that part he will bear the liability. Because, my lord, it was attached and thereafter it was sold. During that period, some, my lord, 7 to 8 months has elapsed.
You have filed an
Yes,
application.
on this short amount, lordship. I will
Which
see the amount.
application?
No, this is a affidavit that where we have placed
No,
the.
you have filed an application. We may
Uh-huh.
consider that.
We'll, and my lord.
When their claim is there, which is yet to be adjudicated, your
We want to
claim
take away
will
entire
claim,
money.
will claim, we'll adjudicate your claim also. Bonus is also, we cannot ignore.
Yes.
At par.
Because that will come first, my lord, because liability of the labor.
But PF
No,
has
in
to
fact,
Say,
my
no,
lord,
Mr. Gogoi, whether they are secured creditors, whether you are workman, all those will have to see or have to be seen. If they are secured creditors, they stand at par with the workmen as per the Companies Act. Now, we have to go by the spirit. You cannot ignore a secured creditor, you cannot ignore a workman, the
Right.
claim of a workman.
Right.
Bonus, yes, but you file an application.
my lord, because
File an application.
time in the different.
You should have filed it before if you're concerned with that.
And they are.
We can have this on Monday?
No problem.
Yes,
They are asking one thing, they are asking 20% of the bonus, which is a loss making.
that lordship will
And
decide.
no, they have sold this garden. If the ATCL was so interested to keep this garden, because it is the ATCL assembly is there, why this 20% bonus they want, loss making, and you sold it. Minimum is 8.33%. And that is auction money. It is only they have auctioned it and all proceedings are lying PF. PF also should come and file an application. What is the amount that is lying with them?
They
What
have
is the
said-
bonus?
They have said,
No, they should file an application.
you state, we put the status, what is the amount which
Yes.
was fetched by you in the auction?
Transparency,
How much
yes.
amount did you release in the meeting?
Correct.
Their lordship can it be on Friday? Because of
Friday
time
will be
constraint.
difficult, my
Next Friday will be difficult.
Not this Friday, my lord.
Day after
This-
tomorrow.
Yes,
Day
sir.
after tomorrow, I
What
have
I
some
think-
difficulty. No,
Monday.
Monday.
Before that, I will file the, my lord,
You can have your instructions in a written manner. We'll consider it. Mr. Das, Mr. Bora,
My lord.
you can have it in a written instructions. We'll,
Yes, of course.
Only a copy will be given so that.
Yes,
we
yes,
will
yes,
also-
yes, heard Sri D. Das Learned Senior Counsel assisted by Sri A. Ganguly for the petitioner. Also heard Sri J. Bora for the,
For ATPF.
for ATPF.
Oh.
ATPF, pura likhe diya. Whereas Sri Gogoi, B. Gogoi, Learned
Yes.
Counsel is entered, is present for the respondent number,
my lord, the respondent two.
respondent number 2. Para. On request, The consideration of this matter is deferred to Monday next. Full stop. The learned counsel for the respondents are directed to obtain necessary instructions and place the same on record. Para. The respondents may also file necessary applications for liberty is also granted to the respondents to file further application in this matter.
Copy did copy
On Monday in that case.
only Friday they will serve the
Monday.
No,
Next
before
Monday.
that we'll find out. By Friday we'll find it.
Yes, DPO.
All right.
We'll have it on 22nd. Yes.
Malo, in this case, petitioner is paying report authorization for supply of certain documents under RTI Act. And as per page 22, the direction was issued to the respondent number 6, Thamaji Arafmin. And
R6 has filed affidavit on
yes,
6 9 2025.
Malo, in the affidavit, they have stated that they are bound to supply the information only for 5 years, not beyond that. But as per RTI Act, section 8(3), they have to retain the document for 20 years. Being the public authority under the state government control, they have to supply, my lord. They stated that we are bound, we have only 5 years document.
We are not bound, but we have maintained the records only for the last 5 years that we have stated.
That
Yes.
prior to that, they have not explained why they are not maintaining the document from 11 to 2020.
Would you like to file any rejoinder affidavit?
Only that issue, my lord.
If you like, you can give you some time to file rejoinder.
Yes.
Since you have would be arguing on that aspect.
Yes, ma'am.
The affidavit in opposition by the respondent number 6 has been filed on 6/9/2025. Para. Sri Sharma, the learned counsel for the petitioner, prays for and is granted 2 weeks' time.
Yes, ma'am.
To file rejoinder affidavit. List after the vacation along with the rejoinder affidavit that may be filed.
Possible date, my lord. Date may be fixed. Any date.
List after the autumn vacation.
Right.
And Sharma. And Sharma. 29. What is this matter about?
Well, we have started construction of boundary wall over our plot of land. What
means? What is the land? APGCL.
APGCL. These are our patta land.
Okay.
And they have objection as regard construction of the boundary wall. They said that they are possessing the land. In fact, those are our patta land and they are in encroachers below. We have filed the affidavit in opposition and we have shown the identification of the land has been done. Report of the circle officer is there. And
You have completed the constructions.
boundary wall, Lordship has allowed us to construct and only the
Ingress, egress.
ingress and egress, they are to be allowed with our main gate.
Yes.
They are doing that, my lord. Page number 48, kindly see.
No, they are not present today.
That's true.
We'll have it after the vacation.
Lordship.
Now,
Lordship, give it a date, Lord.
none appears on call on behalf of the petitioner. Whereas Redina Planet Standing Council, APGCL, is present along with Sri Ann Goswami, the Learned State Council. Para, in the interest of justice, matter is adjourned to be listed after the autumn vacation.
Can you give us a date?
List on 17th of October.
Lordship.
I did surely. Rejoinder file.
My lord, we have filed affidavit in reply, my lord.
Okay, you have filed 11/9/2025.
Yes.
Okay.
And my lord, matter may kindly be adjourned for today, my lord. Mr. J. Kalita engaged counsel. He was here in the court, but
for some urgent reason, he has to
Okay,
leave. the metro.
is there any urgency involved? 25 matter will have after the autumn vacation.
No urgency because we have paid the entire amount, my lord.
Okay. A prayer for adjournment has been
And
made
he will kindly
on behalf
furnish a copy of
Sri
the.
J. Kolita, learned counsel for the petitioner. Para. Sri G. Goswami, learned additional AG, is present for the state respondent. For NHIDCL, Sri Sunsa Bora, D. Botman, learned counsel representing Ms. R. Bora, is present for the respondent number 2 NHIDCL. Para. List after the autumn vacation.
My lord, he will furnish a copy of the reply because I don't
Not given to you.
No, we have
Yeah,
already
possibly,
filed.
perhaps, possibly, my lord, it was served.
You
with
have
the-
another
I
copy.
will furnish. a copy.
The learned counsel has for the petitioner has undertaken to serve an extra copy of the affidavit in opposition to Sri.
Reply, affidavit in reply.
In reply, yes.
Affidavit in reply to Sri Goswami during the course of the day.
Okay.
My lord, I'm not aware of that.
Learned counsel for for the petitioner undertakes to serve the relevant documents of repetition of the petition and affidavit to the learned counsel for the respondents.
Yes.
Yes,
Much
please
obliged.
do that.
No, I can do it. Obliged. So after vacation, right?
My lord, in this item 31, my lord, we have filed our affidavit in opposition today, my lord. Copy already served, my lord.
Mr. Sharma, they have filed affidavit.
We have served copy. Served copy, my lord, I received.
Would you like to file any rejoinder affidavit?
I think that at the very outset, my lord, the case is come for the admission. The record is very much necessary. my lord. If the record has not come, that it may be the something. We have no trust about the Dima Asauko, in the Dima Asauko. They have not received my application. They have not given my the certified copy. They are not passing the orders. In this way,
No, if there is any such doubt, we'll see at when the doubt arises. Now, you are for whom?
I am for respondent 1, my lord, the earlier husband of the petitioner.
And
I am for respondent number 2, your lordship.
Dimahasao.
Dimahasao, lordship.
Would you like to file your
Yes,
affidavit?
your lordship.
You file your affidavit?
Yes, I have received all the documents, your lordship. That,
Okay, you file affidavit.
yes, your lordship.
Third, Sri B. N. Sharma, learned counsel for the petitioner. Sri B. Barwa, learned counsel for the respondent number 1,
Yes.
has submitted that the affidavit in opposition has been filed today,
Today, my lord.
which however has not been tagged with the records. Para. Ms.
R.
R. Decker, learned counsel for standing counsel, NCHAC, submits that the instructions have been received, based upon which she will file the affidavit in opposition. Para. List after 4 weeks to enable the parties to exchange further pleadings. You can also file your rejoinder if you want. Okay.
44 and 45.
I think repeat it, sir.
Eh?
Repeat it, sir. I have not joined the
Lordship, an affidavit was filed, your lordship.
Who has filed affidavit?
Lordship, on 15th, your lordship, the affidavit.
Revenue Department.
Yes, the
Okay.
affidavit may not be tagged, your lordship.
In Sunil Deka, which case? Hawks case.
Neil Deka and Debu Kumar Das in both.
It
the
is there,
matters.
15-9, it is there.
Yes, your lordship.
15-9 is there.
Lordship,
Yes, I'd like to file a rejoinder, Mr. Hawk.
Yes, my lord.
The
Otherwise, my
notification
lord,
is tagged, your lordship, annexure number 1,
That
page
notification does-
37.
If it is not necessary, then we'll try to dispose of without your rejoinder.
My lord,
If you think
my lord, next week, it may be fixed, my lord.
next week will be difficult.
My lord,
Last week is a motion day. We'll go after the vacation.
my lord, my lord.
Okay, if you want, you can file your
Yes, yes,
rejoinder in the meantime.
Yeah, I'm fine. That is why, my lord. What I was submitting, my lord, if lordship fixed next week, my lord, by this week I'll file when the result.
Next week, it's next week not possible. No motion. I heard You are in both the cases, Mr. Hawk?
No, my lord, I am Sunil Tika, my lord.
And the other one? Who is
Yes,
appearing in the other case?
yes, Islam, my lord.
Where is he?
That not there, my lord.
You are with Mr. Hawk or Deck?
Yes, sir.
Okay. We'll not say anything then. Miss Anne Bodola, Learned Standing Council Revenue Department has submitted that affidavit in opposition in both these writ petitions have been filed on 15/9/2025. Clara? The Learned Council for the petitioners pray for some time to obtain instructions / file rejoinder affidavit. Clara?
Right.
List,
14, my lord.
not 14, list on for 24th of October 2025.
Actually, there is some urgency, my lord. There is
13th
time.
were reopening, then 28th and 21st are holidays were
Yes,
for 24th of October.
my lord, my lord. I am obliged.
Oblige your lordship.
Okay, that's again. Hearing at us. What did you put? If the councils are present, we can complete the orders.
33 I am here with.
33. No, we'll go serially. Yes. 16 matter. Yes.
Malata, here in this case, there is no contact with the petitioner, Malata.
So we close this.
And it's better, Malata. I think the cause of action also, whether it exists or not.
But you are legal aid council.
Yes,
How can we close this?
that's the problem, Malata. I have already contacted with the
No,
office.
not required. Contact is not required. You can argue your case. If cause of action is there, legal aid council will not be proper. Had it been a private council, we would have dismissed this.
No, Malata, the only problem is that the respondent number 8.
Okay, we'll consider at 2 o'clock then. This will require some
Yes,
time.
yes.
Okay, 2 o'clock. And others? We'll sit at 2 o'clock.
Yes. Initially, an FIR lost by the husband of the present petitioner, Malata, regarding kidnapping of their daughter. As alleged in the FIR, that the daughter of the petitioner was kidnapped on 8/4/2013, and thereafter immediately they have lodged an FIR before the officer in such Nalbari Shodor police station. And then the police has failed to find out her daughter, and thereafter on 29/4/2013, the daughter of the petitioner herself along with the boy present in the police station. On getting the aforesaid information, the petitioner along with her husband and their relatives went to the police station. But the police did not allow them to enter into the police station to meet their daughter. And on that issue, the police officer, that is the respondent number 7 and 8, as alleged by the petitioner, that assaulted the petitioner and her husband. And coming back from the police station, she lodged an FIR against the police personnel. When the police did not take any action, she submitted an application before the Superintendent of Police, Nalbari district. And that too also, no action has been taken. Then the file and writ petition before this Honorable Court, kindly peruse the page 23.
Yes.
And the relevant portion is at page 24. This writ petition was filed alleging inaction on the part of the police authority in respect of FIR dated 4/5 to so-and-so, lodged with the Nalbari Shodor police station, forwarded by the annexer for representation dated so-and-so, series so-and-so, for the petitioner submit that pursuant to the FIR, now the police has registered a case being Nalbari PS case number so-and-so, in view of the above, writ petition is disposed of. Then after investigation, police submitted a final report. And the petitioner submitted a Naraji petition before the concerned court, my lord. And then kindly come to page 30, the order of this learned court below, my lord. Page 30. The complainant is present, peruse the statement of the complainant as well as her witnesses. It is found from the materials on record that the accused Sudhanshu Shuklavedya and Meserali had committed the offense under section so and so IPC, but they are public servant and sanction under section 197 CRPC is required because offense was committed during their official duty. So complainant is directed to acquire necessary sanction from the GOP to try the case against the accused person. Complainant shall take steps. This court will take cognizance after receiving the sanction order fixed on author so and so. Thereafter, the
Yes.
Additional Director General of Police, well, kindly page 33, rejected to give the sanction against the state hearing officers. Page 34 is the relevant. In view of the investigation of the case and the report of the Superintendent of Police Nalbari, it reveals that there is no evidence against the alleged OC Inspector Sudhanshu Shuklavedya and others for according prosecution sanction. And having regard to that, this present requisition has been filed. And after filing this requisition, notice was issued. And in respect of the respondent number 7 and 8, notice was not served. Subsequently, the earlier counsel was continuously absent. Then the matter was given to the legal aid counsel to me in the 2021. Then I have taken again steps. But in respect of the respondent number 7 is concerned, as per the last Lozima order, madam, order dated last Lozima order dated 28/8/2025. In respect of respondent number 7 is concerned, the learned counsel has already entered appearance. But in respect of respondent number 8, till that service has not been completed, though I was directed to take the dusty service, and I have taken the steps and routed through the registry mallet, I have received it, but I could not contact with the petitioner. The numbers which is given in my letter, that was also could not be communicated mallet.
Okay. Seven is complete.
7 is complete.
Not appeared.
Today not appeared, but her name has been reflected in the cause list.
Who?
Some MS. MM.
As Devnath.
As Devnath. No. As Devnath was the petitioner.
Lawyer of the advocate of the petition.
Dipankar Nath.
Dinath.
No, G. Assam Dinath and MS M. Sharma for respondent number.
Well, they filed one of them. I have the second copy.
Huh?
The Dipankar.
M. Sharma is also there. The M. Sharma name is
Who is M. Sharma?
MS M. Sharma.
Moirakshi Sharma.
MS, Miss M. Sharma.
Dinath, I think, Mallet.
Okay. Okay, what is your case?
But my case only is that since the learned trial court, after taking the evidences, has given a decision that there is a prima facie materials against the hearing officers. So prosecution sanction is required to continue with the
Trial.
case. Yes. That is my case.
No,
How can the DGP, on the basis of the final report submitted by the police, can take a decision that there is no prima facie materials?
No, it's not like that. Yeah. See, 197 sanction is a safeguard given to government servants.
Yes.
And magistrates.
Yes.
And you know the implication of 197.
Yes.
So the sanction is a prior requirement for proceeding against them. There is no doubt that this 7 and 8 are government servants.
Government servants.
Now, there is an order passed by this sanctioning authority on 23/2/2015,
Yes.
refusing to grant sanction. Now, you cannot, that cannot be a defense or a
Yes.
ground, that since
Yes.
the court has expressed that there are materials, but the
Yes, ma'am.
sanctioning authority has to apply his independent mind whether a case to proceed against them is made out. He has said that there is no, now you can challenge, you have challenged this, you can assail this on your, you can formulate your grounds, why this is not, why this is bad in law, which facts are irrelevant, which facts are extraneous, which have been taken into consideration. Let us read this order of 23 to 2015.
My lord, page 33.
Yes, correct.
With reference to the above, I would like to inform you that after receipt of the letter under reference, this headquarters forwarded the letter along with the enclosure to the Superintendent of Police Nalbari to furnish a detailed report on Nalbari Court case number so and so, the Nalbari PS case number 360/2013 under section so and so, and accordingly the Superintendent of Police Nalbari submitted a detailed report on the case. The report of the Superintendent of Police Nalbari as follows. On 6/5/2013, the OC Nalbari PS received an FIR through register post from one Mosammad Gulban Begum, that is the petition novel, under Nalbari PS regarding kidnapping of her daughter Miss Sajina Begum. This refers to Nalbari PS case number so and so. On 29/4/2013, the LS kidnapped daughter Miss Sajina Begum and her newly married husband, namely Abdul Sattar Elajdi Babul, surrendered at the PS, and they had loved since before. On their surrender, the complainant Musammad Gulman Begum and her husband Taleb Ali and a group of associates come to Nalbari PS and forcefully tried to take away their kidnapped daughters from the PS. At this, Inspector OC so-and-so Shuklobaddo with the Siresta ASI obstructed them in their illegal act and suggested them to go to the court of CGM, Nalbari, where the girl would be produced. But the parents of this girl started halla at the PS. On receipt of information, Additional Superintendent of Police Headquarters Nalbari, Additional Superintendent of Police so-and-so Nalbari, and Deputy Superintendent of Police Headquarters Nalbari arrived at the PS to monitor the situation. Somehow, the OC and the staff of the PS took the victim girl to the hospital for medical examination, and from there, she was produced at the court of CGM Nalbari. And after recording her statement under section 164 CRPC, the court allowed the girl to go on PR. The girl then went with her newly married husband. At this, the complainant Musammad Gulban Begum started hue and cry and fell down in the court veranda at about 4:30 p.m. She was then taken away from the court campus by her associate to the SMKC hospital for treatment. It is to be mentioned that SI Messerali of Nalbari PS lodged an affair against Musammad Gulban Begum and others for their attempt in forceful taking away of the kidnapped girl by so-and-so PS. This refers to Nalbari PS case number so-and-so. On 7/5/2013, Musammad Gulban Begum lodged an FIR at Nalbari PS by registered post stating that on 29/4/2013, when she went to Nalbari PS to meet her kidnapped daughter, Miss Sajina Begum, the OC Inspector Sudhanshu Shuklobaddo rebuked and threatened her and pushed her out from the PS, and she fell down in the ground. She sustained injury on the bones and chest. At that time, SI Messer Ali also dragged her out by pulling her hand. Her husband Taleb Ali Ahmed was detained in the PS and she was admitted in the SMKC hospital Nalbari. On receipt of the FIR, a case by Nalbari PS case number so-and-so was registered, and Sri Gyasuddin Ahmed, APS Deputy Superintendent of Police Nalbari, investigated the case. During investigation, IO drew up a sketch map of the PO, examined the complainant, some impartial witnesses, including the complainant's daughter, Miss Sajina Begum, and recorded their statement under section so-and-so. The statement of the disinterested witnesses and Miss Sajina Begum, recorded under section so-and-so by the judicial magistrate at Nalbari Court, did not corroborate the facts of the FIR. The report of the Superintendent of Police Nalbari submitted to the AP headquarters revealed that the facts of the FIR are not based on facts, and therefore the IO, after completion of the investigation, returned the case in FR by FR number so-and-so as evidence insufficient against the Inspector Sudhanshu Shuklobadda and SI Messer Ali. According to the opinion of the Superintendent of Police Nalbari, the case is not fit for granting the prosecution sanction against the OC Inspector Sudhanshu Shuklobadda and others. in view of the investigation of the case and the report of the Superintendent of Police, Nolbari, it reveals that there is no evidence against the alleged OC Inspector Sudhanshu Kluveddo and others for according the prosecution sanction.
Yes.
But here from this, the contradictory story is there. The petitioner's history is totally different with the history of the police. My lord.
Now, what is, see, ultimately you have assailed this 23-215 order.
Yes.
What are your grounds?
My lord, my humble submission before your lordship, since the Director General of Police completely based on the report, that is the final report as well as the report of the Superintendent of Police. And the story which has been put forward here is totally different with the petitioner, my lord. So my humble submission, that as per the evidences taken by the learned court below, that there is some prima facie materials against them.
No, court did not take any evidence.
My
That
lord,
was
the
the first day.
witnesses examined.
No, that was on the first day,
Yes,
200.
first day, first
200.
only. Evidence not.
Not even, that is the statement.
That examined
200.
statements has been taken, some individual witnesses also. So in that regard, my lord, my humble.
Now, are you making a submission that the alleged offense were not committed as a part of the official duties? You can have a scope to make an argument on that regard. See, it's only official duties which are being protected under 197.
Yes.
In discharge of official duties. This act was it in discharge or in purported discharge of official duties. That is the expression of 197. Let us see 197.
Yes.
PRPC. Please read. When any person who is or was a judge or public servant not removed from his office save by or with the sanction of the government is accused of any sanction offense
Of any offense
alleged to have been committed by
him while
acting or purporting to act. See, it's a very vast area. Protection is very vast. Not only acting but purporting to act.
In the discharge of his official duty, no court shall take cognizance of such offense except with the previous.
So the court has not said that court has simply said you get the sanction,
then
we will proceed. Now, therefore, you are challenging the order of 23/2015, whereby the sanction has been declined.
Declined, yes.
Now you have to make grounds why this is not sustainable in law. Yes, Mr. Nath.
But here, my lord,
You appear for whom?
I filed the Wakalatnama for the respondent number 7, my lord.
Yes.
So basically the orders are against the orders which here the petition has challenged, my lord. Those are refusing reject this prosecution sanction in favor of respondent number 7 and 8. And in fact, on the basis of materials which were placed before the authority, it is the Completely, it is within the domain of the authority, my lord, whether on the basis of those, the prosecution sanction will be given or not. Because section 197 is a protection given to the government employee while discharging their duties. And rightly, after considering the materials placed before the authority, it was refused, my lord. And only on the basis of the statements, my lord, the order need not be interfered, my lord.
Decision is put to challenge. What do you say? Mr. Nath is for the respondent seven. Seven is not the decision-making authority.
No.
Decision-making authority is
The Director General.
the Director General of Police, who has passed this order, ADG, on 23/2/2025.
2015.
2015.
Yes, ma'am. In fact, the order is a detailed order, page 33 is a detailed order. He has discussed everything.
Your daughter has not supported you.
Yes, that's correct.
In her
Not supported.
164,
Clearly,
she has not supported you. And daughter, we have examined, she is not a minor.
measure.
She was in the 4th semester
Yes.
of arts.
Arts degree.
Okay, Dekha.
In fact, that aspect was recorded in the order, itself.
Please have your seat. An order dated 23/2/2015 issued by the Additional Director General of Police A, Assam, by which the prosecution sanction in respect of respond number 7 and 8 has been declined is the subject matter of challenge in this present writ petition. Para. The facts put in brief is that the husband of the petitioner had initially lodged an affair on 8/4/2013, alleging that their daughter was kidnapped. Full stop. Based on the aforesaid affair, on 29/4/2013, the daughter, along with the person against whom the allegation of kidnapping was there, had presented themselves before the police station. And the petitioner, along with her husband, had also visited the police station. However, it has been alleged that the petitioners were not allowed to enter the police station, and rather the petitioner and her husband were not allowed to enter the police station, and rather the petitioner was assaulted, for which the petitioner had lodged another FIR. Full stop. The FIR was, however, at the lodged another Ejahar. The Ejahar was, however, not registered, and therefore the superintendent of police, Nalbari, was approached, and as no action was taken even thereafter, the petitioner had filed a writ petition before this court, which was registered as WPC 2790 of 2013. Full stop. During the pendency of this writ petition, this court was, however, apprised of the fact that Nalbari PS case number 360/2013 under section 354/355/325/506/342/34 IPC was registered and investigation was on. Full stop. On such appraisal, the aforesaid writ petition was disposed of on 26/2013 by directing the respondents to carry out the investigation. Full stop. This said investigation had, however, culminated in a final report which was laid on 22/12/2013. Full stop. The petitioner has claimed to have filed Naraji petition against the aspect of acceptance of the final report. Full stop. The learned CJM Nalbari on 12/5/2014, after examining the matter, had, however, made an observation that since the accused persons are public servant and the offense alleged has been committed in that capacity, sanction under section 197 CRPC would be required. Full stop. The complainant, that within bracket petitioner, was accordingly directed to apply and obtain necessary sanction for further necessary sanction. Full stop. The matter was accordingly placed before the sanctioning authority, who, via the impugned order dated 23/2/2015, has declined the sanction. Full stop. It is the validity and legality of the aforesaid order which is the subject matter of challenge, and which have been questioned in this present writ petition. Para. I have heard three R. Islam Learned Counsel for the petitioner. I have also heard three
Legal aid counsel.
Learned Legal Aid Counsel for the petitioner. I have also heard three N. Goswami, Learned State Counsel, as well as three D. Nath, Learned Counsel for the respondent number 7. Full stop. It may, however, be mentioned that initially this writ petition was filed through a counsel who, after some dates, was not appearing, and accordingly Sri R. Islam, Learned Legal Aid Counsel, was appointed to assist the court on behalf of the petitioner. Para. Sri Islam, the Learned Legal Aid Counsel, has submitted that once the Learned Court of CJM had found prima facie materials to proceed, such sanction could not have been refused, vide the impugned order dated 23/2/2015. Full stop. It is submitted that the petitioner's Naraji was duly considered by the Learned CJM, as would be reflected in the order dated 12/5/2014. Full stop. It is also submitted that the sanctioning authority had simply relied upon the report of the OC and the Superintendent of Police to come to the aforesaid finding. He accordingly submits that the impugned order be interfered with and sanction directed to be given for proceeding against the respondent number 7 and 8. Para. Per contra, comma, Sri Goswami, the learned State Council, has submitted that the sanctioning authority had applied independent mind in accordance with the provisions of Section 197 of the CRPC, which grants protection to a to a public servant in discharge who is accused of any offense in discharge of his duties. Full stop. He has submitted that the relevant factors have been taken into consideration by the sanctioning authority, and therefore the order is not liable to be interfered with. Para. Sri Dinath, the learned counsel for the respondent number 7, has submitted that the case against the petitioner, against his client, was instituted only as a counter blast, as the initial allegation of kidnapping had turned out to be an incorrect allegation, as the daughter of the petitioner had got married to the alleged kidnapper. Full stop. He has also submitted that all these facts have been taken into consideration by the sanctioning authority before arriving to the decision not to accord sanction, which is reflected in the impugned order. He accordingly submits that the writ petition be dismissed. Para. The rival submissions advanced by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully perused. Para. Section 197 of the CRPC is on the requirement of sanction for prosecution of, amongst others, public servants. Full stop. The aspect of such sanction has been discussed in a catena of judgments of the Honorable Supreme Court. Full stop. This court, in the judgment, in the case of what Dwara? Tulumoni. In the case of Tulumoni Dwara versus State of Assam, has, after taking into consideration, after taking aid of all the previous judgments, has made the following observations. Tulumoni Dwara, how will a bare perusal of the impugned order dated 23/2/2015 would show that the sanctioning authority, namely the additional Director General of Police, A Assam, had taken into consideration all the relevant facts. Full stop. The aspect that the daughter of the petitioner, who was alleged to have been kidnapped, has also made a statement under Section 164 CRPC, in which she has not supported the case of the petitioner. The sanctioning authority has also taken the report of the
investigating officer who had recorded statements under section 161 CRPC and had also taken cognizance of the report of the Superintendent of Police, Nalbari, on the allegations made by the petitioner against the respondent numbers 7 and 8. Full stop. In fact, it was after a detailed investigation that the investigating agency did not find any materials to proceed, which led to laying of the final report on 22/12/2013. Full stop. Though the learned CGM, vide order dated 12/5/2014, appears to have taken a view that a case may be proceeded, which however would require a sanction under section 197 of the CRPC, the sanctioning authority, vide the impugned order, has come to a conclusion that no case was made out for grant of such sanction. Full stop. It is not in dispute that the allegation against the respondent number 7 and 8 were in connection of they performing their official duties. Full stop. It is also not the case of the petitioners that the requirement of sanction under section 197 CRPC would not arise in the present case. And in any case, the order dated 12/5/2014 passed by the learned citizen is not the subject matter of challenge. Full stop. This court, in exercising certiorari jurisdiction under Article 226 of the Constitution of India, would be primarily examining the decision-making process. Full stop. In other words, the examination would be within the contours as to whether the relevant factors were taken into consideration or as to whether the impugned decision is based on irrelevant factors and extraneous consideration. Full stop. In the considered opinion of this court, the impugned order dated 23/2/2015 appears to be based on factors which are relevant and germane to reach a conclusion which has been done. Full stop. In view of the aforesaid discussion, this court is of the view that no case for interference is made out, and accordingly, the petition is dismissed. Tularam to Tulu Moni to Laidaba. Duara. Amal Kotu.
Let me be password for the time being, Lordship. Mr.
And it is
R.
not possible.
Mr. R. Professor, you will appear in this matter. He's on.
What is this matter?
Lordship, it is about demarcation, Lordship. There are two lands. So this in this lands, there are some kind of eviction, there are some kind of encroachers in that land. And these lands have been considered as PGR lands, Lordship, professional grazing lands, whose only purpose of this lands is for professional grazers to graze their animals, Lordship. But some encroachers are staying there, or have also made some certain locality, and this and writ petition was also filed, and in that order it was said that, Lordship, demarcation should be done, Lordship, of this land, and only after demarcation the encroacher should be.
This is a contempt matter.
Yes, Your Lordship.
Where is the order of this court?
Lordship,
which order has been violated?
Lordship, the order is in page number 9, Lordship.
9.
Yes, Your Lordship. This order has been violated, Lordship. Lordship, the directive part is in page number
1-4.
Yes, Your Lordship. And Your Lordship, as per our instruction from the client, the demarcation process has started, Lordship, but it is yet to be completed.
Now, what is your grievance?
My lord, the grievance is that those people are, my lord, means they have encroached this land and they are using this land for some other purpose which is not grazing, lordship.
Who are you?
Lordship, I am the petitioner, lordship, Dharmakanta Charaya and Khagan Kuli, lordship.
And
And
that we know, we know your name. What was your grievance in the petition?
Lord, in the contempt petition, my lord, we have in page number 5, lordship, in point number 6, we have said that, lordship, that the demarcation should be carried out, lordship. It is not, the demarcation was not done, lordship. And only after demarcation, only the eviction can be done.
Yes, Mr. Borpatari.
We have already filed one, my lord, status report, which says that, my lord, it has been complied with. Now they are raising disputed question of fact. Because
Have you done the demarcation?
yes, that is what our compliance report says, my lord. It is marked with letter X. So the direction was only with regard to demarcation. It's a big area, my lord, running to thousands of bighas. It's somewhere, my lord, in that Hemaji district. Now the area suffers from the phenomenon of, my lord, alluvion and diluvion. So these things are also there. And by efflux of time, my lord, at the time when
It has been done, Mr. Counsel.
My lord, as per the instruction which we have sought out from our means the client, they have said that it is yet to be completed, lordship.
No, this of 2024 says the demarcation was done way back in February 2022.
they were called for meeting, all the stakeholders were called for meeting. And my lord, what has happened here, my lord, on the day when this honorable court has disposed of the writ application, my lord, thereby directing the authorities to carry out a demarcation process for demarcating the PGR area, the progressive grazing area. These writ petitioners now, my lord, they claim themselves to be professional graziers. So their main complaint was that, my lord, their professional grazing lands have been, my lord, diminishing day by day. So therefore, it has to be demarcated. So now when this writ petition was disposed of, my lord, at that stage, my lord, it was found that already there are several establishments where have come into existence. Now they cannot be removed. It was only a case of demarcation. It is not a case of the removal also, because that will create a law and order situation. All these things are there, my lord.
My lord, but
So therefore, meetings were held and affidavits have already been filed, my lord, by the respective, my lord, contemners, respondents. Now, in the meantime, my lord, the incumbents have also changed their offices. Now, no new incumbents have been brought in, my lord, by them, although they were directed, my lord, to do so. Nonetheless, my lord, this report says, my lord, that everything has been done.
But the direction was not confined to demarcation. Direction was that after demarcating,
Yes.
after completion of the work of demarcation of the PGR,
Yes.
they said to respondents, if required, after the demarcation, would carry out necessary activity of eviction.
Eviction.
What activity have you taken?
No, it has already been, my lord, demarcated, and, my lord, no untoward, my lord, incidents have been reported. So thereby,
What is your name, Mr. Counsel?
thereby, my
Shall your lordship.
Mr. Ghosal, have you alleged that after the demarcation there are illegal encroachers on the PGR?
This is not done, but lordship, as per the conversation with our client, he had said that it is ongoing, but it is not completed, lordship.
Difficult. And this is pending since 2018.
Yes, so therefore,
Hard.
it is only,
What,
my lord,
Kushal?
Your lordship, may this matter come up after 1 month, lordship. In the meantime, lordship, if the demarcation.
We are not having contempt. D. Ghoshal.
A. Ghoshal, your lordship.
On behalf of?
M. Bishwas.
Heard 3 A. Ghoshal, Learned Counsel, appearing on instruction of 3 M. Bishwas, Learned Counsel for the petitioners. Also heard 3 R. Borpujari, learned counsel appearing on behalf of the respondent numbers.
1 and 3, as originally they were, my lord.
Original respondent numbers 1 and 3.
Yes, we have filed our affidavit.
Sri Borpujari has, however, informed that the said respondent numbers 1 and 3 are no longer holding the post, but had filed the affidavit in opposition. Para. Please have your seat. The allegation in this case is regarding willful and deliberate disobedience of an order dated 6/1/2017 passed by this court in WPC 3494 of 2015. Full stop. The said case instituted by the petitioners was filed for a direction for demarcating the PGR land as per the notification dated 10/12/2010. Full stop. It is the case of the petitioners that vied an earlier notification of 1992, 15,735 bighas of land was notified as PGR, which were being encroached, which leading to diminishing of the grazing area. Full stop. Para. This court the aforesaid order had disposed of the writ petition by directing the respondent numbers 2 and 5 to carry out the demarcation of notifications. Go to Kiris. To do as per PGR land for two areas, namely 2185 bighas notified on 1/12/1992 and 15,73 bighas notified on 10/12/2010. Full stop. By the said two notifications, the aforesaid land was earmarked as PGR land. The petitioners had contended that no action was taken for compliance of the judgment, compliance of the aforesaid directions, and therefore the contempt petition was instituted. Full stop. After issuance of notice, the contesting respondents had filed affidavit in opposition. Sri R. Borpujari, learned counsel, has submitted that apart from the affidavits wherein the allegation of willful and deliberate disobedience has been refuted, he had obtained up-to-date instructions in April 2024, as per which the demarcation was completed in February 2022 itself. Full stop. The said communication dated 3/4/2024 was presented before this court earlier and has been made part of the records and marked as flag X. Full stop. This court has examined the aforesaid communication dated 3/4/2024, as per which the area in question was demarcated in February 2022. Full stop. The said communication has also dealt with the aspect that in certain portion of the landmass, there were encroachment by erosion affected people who practice cultivation. And the entire area was situated in a very remote and difficult terrain with no proper communication. Full stop. Thereafter, in October 2021, cadastral survey was conducted and the notified PGR area was demarcated, which was completed in February 2022. Full stop. Para. From the aforesaid communication and the materials and the contents thereof, it appears that the order in question has been substantially complied with. Full stop. This court is of the considered view that unless the non-compliance is deliberate and willful, there would be no requirement to proceed under the Contempt of Courts Act 1971. Full stop. In view of the above, the contempt case stands closed. Next.
I'm so obliged.
Yes.
May it please your worship. Worship, matter may pass over for the day, lordship. May be fixed after entering vacation, lordship.
No, 2018 matter.
Some instruction needs to be taken.
2018 matter cannot be passed over like this.
For us, matters become infructuous, lordship.
You have not even taken steps for response number 6.
Unable to contact the petitioner, lordship.
Then we close it. What is the
After vacation, it will be convenient, lordship.
In this case, notice was issued on 12/10/2018. And steps were directed to be taken by registered post with AD on response number 6. Thereafter, the matter had come on 17/12/2018 when service report on the response number 6 was said to be awaited. Office note dated 6/9/2025 has however reflected that the Learned Laws Court vide order dated 27/8/2025 had directed the petitioner to take fresh steps for service of notice upon the response number 6 by registered post with AD within 7 days, which however has not been done. Full stop. Your name?
D. Roy, lordship.
D. Roy, the learned counsel for the petitioner, has also submitted that there is no contact with the client. Full stop. Para. In view, also hearts free.
Number 1, my lord.
C. Borwa, learned
R1.
standing counsel for the NHAI, as well as the N. Goswami learned state counsel. Para. It appears that the petitioner is not interested to prosecute in prosecuting the matter. But accordingly, the petition is closed. Full stop. It is however observed that in case the petitioner shows his interest, applications may be filed for restoration of the
Well, can an observation be kept in record, like in further, if there is an acquisition process, there will be.
We have already said you can restore this. For a further acquisition, that's a separate cause of action. You can always come. Yes, next.
Obliged.
No. Interim orders can be located too. If any. applicable. Yes.
Lord, this writ petition, Lord, in fact, is not maintainable at all. There is a proceeding, my lord, admittedly, my lord, they have filed themselves before the, my lord, the NCLT, my lord, NCLT, yes. Insolvency Adjudicating Authority. It's a pending there, my lord. And CIRP, that is a corporate insolvency resolution process. It is the instance of the pro forma response number 5. In view of that, my lord, this writ petition is not at all maintainable. And the fact is, my lord, 48 crores of amount, it was, my lord, it was classified as NPA way back in 2021.
You are for whom? You are
I'm for the Punjab National Bank.
So if you are arguing on the maintainability aspect, you are led by Dr. Saraf.
Yes, sir, not sure.
We'll have this for admission hearing,
All right, my lord.
but next week it may not be possible. We'll have it immediately on the reopening.
Reopening. All right.
Okay. Your doctor,
Yes, sir, not sure.
Sri NN Dr. Learned Counsel for the petitioners, has prayed for some accommodation on behalf of his senior Dr. A. Saraf. Para. Sri S. Dr. Learned Senior Counsel for the respondent bank has, however, raised an issue with regard to the maintainability of this writ petition. Full stop. He has contended that parallel proceedings are on in the NCLT, Guwahati bench. Full stop. Para. In view of the aforesaid submission, list this case for admission hearing on 22nd of October.
Yes. Even
2020.
proceeding pending before the civil court also. Nonetheless, my
NCLT
lord.
as well as civil court, NCLT Guwahati as well as civil court.
All right. Right.
May I please?
Yes.
My lord, this matter relates to land acquisition, my lord.
Okay, what has happened?
My lord, but the compensation has not been paid, my lord, till now. My lord, respondent side also has not filed any affidavit, my lord.
The respondent, the compensation will be paid by the NHIDCL lordship. We have already sent the proposal lordship.
You have taken steps for respondent number 6.
My lord, I have taken steps today, my lord. I am sorry, my lord. I have not.
Then you'll have to come up.
Yes, my lord. I missed the item on that.
Peruse the order dated 4/9/2025 passed by the learned laws in my court, as per which fresh steps for service of notice by registered post with AD upon the respondent number 6 have not been taken. Full stop. Para. Your name?
M. Hussain, my lord.
M. Hussain, learned counsel for the petitioners, has, however, submitted that fresh steps have been taken today.
Yes, my lord.
Today. By document number 1/2025 dated 17/9/2025. Para. Registry to proceed for service of notice and list this matter after 4 weeks along with service report. You have a copy of this?
No, my lord.
Make a copy. I have to refer you.
Most obliged.
Lordship, you have taken step upon respond number 2 and 3
However, your lordship, 2 and 3 got transferred. New incumbent joined in place of Krishna Sharma, your lordship. So
Item number
38, your lordship.
Why have you made this respondent number 3 party by name?
Lordship, 2 and 3 got transferred.
2 is the Golpara Municipal Board.
Lordship,
There is no transfer of any municipal board.
lordship,
Why 3 is made party by
lordship.
name?
My learned friend knows. Lordship.
Huh?
I'm unknown, your lordship. My learned friend, Mr. B. Borman. Lordship, I may be allowed to amend the cost time.
No. I has been filed for what? I has come for the first time. You want to change the address of the respondent numbers 2 and 3?
Lordship, along with their names, your lordship.
Why do you want the respondent number 3 to be made party by name? You are not the council.
No, your lordship.
What is your name?
A. Thakuria, your lordship.
Yes, what do you say? He wants the address of the respondent number 2 to be changed and the name of the respondent number 3. Name was earlier the incumbent holding the post of executive officer. You are more interested in the post. Why are you unnecessarily making the incumbent a party? Again, tomorrow, again, this Amitesh Praskwa would change. Then again, there is not a contempt petition. We can allow this. Part 3, A. Thakuria Learned Counsel for the applicant oblique petitioner who by means of this petition has prayed for permitting change of the address of the respondent number 2 and name of the respondent number 3 in the writ petition, full stop. For ready reference, the relevant averments made in the I are expected here and below. Page 4, paragraph 5. नाम के तरफ से 2 and 3. Full stop. It is submitted that during the presentation of the writ petition, it is submitted that due to some change in circumstances, the present amendment is required. Para after Sri N. Goswami, Learned State Council, has not raised serious objection to the present prayer para, considering the aforesaid facts and circumstances. The instant IE is allowed, and the incumbent named above are permitted to be substituted in place of the original respondent numbers 2 and 3 in the writ petition WPC so. Highest is disposed of. Learned Counsel for the applicant is required to file amended cost title in the connected WPC within a period of 1 week.
Highly advised.
Consequently, executive the Gwalpara, who will take notice or no?
Executive by name, I cannot.
No. Gwalpara Municipal Board.
Chairman notice to conference.
No, it's not chairman. Only Gwalpara Municipal Board.
Someone has to represent the lordship.
Huh? Municipal board, can you take?
Lordship.
Huh?
Chairman, I cannot take lordship.
No, Goalpara Municipal Board.
Represented by
If
chairman,
it's
lord.
the chairman, then মোটামুটি হেৰি কৰিলো। After filing of amended cost title, this court would consider the aspect of issuing notice to the new incumbents.
Highly obliged.
May I please, Your Lordship?
Yes.
Your Lordship, your services have been completed for respondent number 4, 5, and 6 as per the Lozima Court order dated 4/8/2020.
Go slow, madam. Yes.
So let the matter be taken up for admission after puja vacation.
4, 5, and 6, have they appeared?
No, Your Lordship.
No.
Who are 4, 5, and 6? Were private respondents?
Your Lordship, 2 are private respondent, 5 and 6, and 4 is Shri Anurag Sharma, APS Additional Deputy Commissioner.
Private respondents?
Yes, Your Lordship.
Okay. What is your name, madam?
N.A. Lashkar.
Ms. N.A. Laskar, Learned Counsel. Are you on record? Learned Counsel for the petitioner by drawing the attention of this court to the order dated 4/8/2025 of the Learned Lozima Court has submitted that service upon respondent numbers 4, 5, and 6 is complete. Full stop para. Upon perusal of the said order dated 4/8/2025 of the Learned Lozima Court, the service upon the respondent numbers 4, 5, and 6 is held to be complete. Para. List this case for admission hearing after the autumn vacation. You're paying for compensation in court. Okay.
Yeah, please, Your Lordship. Well, service of notice upon private respondent number 5 and 6 already completed as per Lozima Court order 10/9/2025. Well, they are not, they are the bank side, they are not the main party. The account number has been freezed by the cyber department. Therefore, government is the main party.
Lordship, his bank account was seized by Cyber Crime Branch, Chennai, Tamil Nadu, Lordship.
Not main party.
No.
No, well, actually, they asked to contact with the nearest cyber department as well as bank. Thereafter, the petitioner visited the nearest cyber department and thereafter come to the Pan Bazar cyber department. They asked to visit the bank and to file a representation. Thereafter, the petitioner visited the bank and filed a representation, but no action has been taken. Malad, actually, what happened, Malad? He was running his business without any problem. On 10/6/2025, one customer has been paid rupees 3,450 rupees to his to the account number of the petitioner through UPI mailer. He is the businessman. How can he know the account number is fraudulent or such and such matter? He is the businessman.
Okay, we'll grant some time to the private respondents if the bank, if they appear. Otherwise, we'll have it for admission hearing after the autumn vacation.
Well, in the meantime, no bar to release the freeze amount, my lord. He is the petty businessman, my lord.
Difficult. Your name?
Zio Ahmed.
Hard. Very same, huh? Same, I hope. Office note. Lozima Court order 10/9/2025, 5 and 6. Huh? Same order. You want to just complete list after the.
Well, the short date may be given and matter may be fixed, my lord. My petitioner is very suffering, my lord. He is very-
On 15th October.
Yes.
15 October.